29.
When do you want?
29.
No, when do you want? 29 next week. All right. Item 29, list this matter next week as paid for. Yes. Any other matter? Bas, d'accord.
Supplementary list item number 1, fresh admission.
Your Lordship.
Yes.
The petitioner session trial is pending before the learned third additional district session judge, Your Lordship, Cuttack, because no PO is there since long, Your Lordship. The learned district judge cannot transfer it because already trial has been commenced and 5 witnesses has been examined. My small prayer, let the matter be transferred to some other court so that the matter can be adjudicated expeditiously.
What is the status of the trial that we?
Annex the order sheet.
7 Your Lordship, here described. Last witness examined on 16/10/23.
Thereafter, another learned was appointed and she was transferred to STSC court. Here, the petitioner was an employee of CRPF. Due to this concocted allegation, he has been thrown out of the service.
Is he on bail?
Yes, Your Lordship.
You take instruction. I'll call it next week. Let the prosecution be given a chance to say
Your
whatever.
Lordship, please.
Only next week. Then I will pass that order. It will come to second ADJ or first ADJ? Isn't it? Or any other court presently in functioning? I can pass that order today, but just to give you one chance. Huh?
All the matters has been transferred from that court because in my case the trial has still come.
It is a part-heard matter, so he won't transfer. There is a circular of the High Court. The part-heard matters should not be transferred, but whether it applies to a case where there is a court not functioning, that you please check up from the GRCO civil, or there is a compendium, the Odisha High Court. Particularly in criminal matters, there is a compendium of circulars and guidelines. Part-heard matters. Part-heard means in the lower court where evidence has begun. Normally, when a matter has become part-heard, it cannot be transferred. But will it apply to a case like this where there is no, even though it's a part-heard matter, but there is no PO? So in such a case, whether that, let us examine it.
Report to the registry. It will be.
No, let us just examine it ourselves.
Yes, I will take it.
Let's this matter next week as per.
Fix a date so that.
Next week means next Thursday. Next,
So next Thursday.
Budhavar, next Wednesday.
Obliged, Your Lordship.
Item number 2,
May the present petitioner's wife, opposite party number, opposite party is the husband. The present petitioner seeking transfer of case from Bhadrak to London Judge Family Court, Raukala.
All right. Notice, stay. Date
13th November.
13th November.
Item number 3,
May I please, Your Lordship? May I please, Your Lordship?
Yes.
Another petitioner seeks a transfer, a direction for transfer of Miss case number 1630 of 2023, pending before the learned first additional district judge come first MSCT court Cuttack to learned district judge come first MSCT court Bargad, my lord.
It's a motor accident case.
My lord.
All right. Issue notice to the opposite parties by speed post, fixing a short returnable date. Requisites be filed by tomorrow. List this matter on Chuti Purur Kora. 9th October.
Grateful.
item number 4,
May I please, Your Lordship? I am in BC, my lord.
Yes.
Am I audible, my lord?
Yes.
Taking up transfer of a civil petition case number 50 of 2024 from Bhavani Patna, Kalahandi to Titlagad, Balangir, my lord.
Yes.
Seeking transfer of civil proceeding 50 of 2024.
Right. Notice, stay. 9th,
13th November.
13th November.
Item number 5,
Obliged.
May I please, Your Lordship?
The present petition is seeking for transfer my lord CP case from Baleshwar to Baripada my lord. In the
Correct.
meantime, my
Notice
lord,
day 13th November.
Item number 6,
oblige my lord.
The petitioner was engaged as Shikha 2008, my lord. 2008. As per the principle, they made regularize the petitioner as a primary school teacher in 2017 with effect from 1/3/2017. Similar matter, my lord, this honorable court decided that the principle of 6 years as applicable to Shikha is to be made applicable. So they have to make regularize after 6 years from 2008. So 6 years coming 2014, my lord. And that order was subsequently confirmed by the honorable appeals court. So my only grievance, my lord, to take a decision in view of the judgment passed by this honorable court.
Similar matters I have
My lord,
disposed of.
already disposed of मोरा पाइल नहीं copy टा. अपन dispose of करते हैं मुझे copy टा पाइल. Similar matter dispose.
I think Mr. Khuntia or Mr. Samal, whatever his name is, Mr. Samal, I think. Mr. KK Swan is associate. What is your good name, sir? Sobhagya Samal. He has copies. That Dhananjay De. We'll pass order. We have. We'll dispose of.
Same order.
item number 7,
Yes.
OP1 to direct.
Yes.
OP1 was direct.
But the secretary. Secretary has to be done.
Right.
Yes. Yes, Mr. Samal.
My lord, that relating to Madan Gopal on this case, Shikha side, the lordship has allowed that writ petition. In the very same impugned order, the present name of the present petitioner will be.
Earlier also there was an application. Earlier also there was an order like this.
No,
Apart from Madan Gopal Nandi.
no,
No,
this was listed earlier.
Okay.
But your lordship.
Oh, you have to whether
I was directed.
you shall
to
examine the
examine-
matter and apprise the court. Yes.
My lord, in fact, my lord, what I found that in the impugned order, it is the name of the petitioner also appears along with the others. And your lordship had specifically dealt in the page number 2 and 3 of the order, my lord, where these petitioners in respect of Madan Gopal Nandi and others who had approached before this honorable court and a common order was passed. But in 2021, when the repentation was rejected, these persons, my lord, they approached, but this petitioner, my lord, didn't
Except
approach.
present petition.
It doesn't matter. He had approached earlier.
No, in the year 2014.
So what? That is how I have to.
Yes,
The- in
They
the case
reject-
of Madan Gopal Nandi and others, what I have, if I remember correctly,
My lord,
they had applied, they had come to this court in 2014. I have given a table.
yes,
my
my
lord,
lord.
my
When they
lord.
have in 2014.
2015.
2014,
Yes, my lord.
on different
Paragraph
dates.
11 is.
Yes, my lord.
Common order-
2014.
A similar order was
2014
passed in all the similar order was passed in all those cases. That they must be considered.
Yes.
Now they were not considered, so they came to the court in 2021. It was rejected on the ground of non-joinder or something like that.
Non-judge.
Non-joinder.
My
All right. Now some of them went to the writ appeal.
lord.
So this is not a case. I held that this is not a case where the petitioners had never approached the court and have come only after the order passed in the writ appeal.
In
So they cannot be
purpose of
treated as fence-sitters because they came in 2014.
To that extent, my lord, the petitioner is squarely covered. Only I just wanted to point out, my lord, that
Only this distinction.
no, is 2021 rejection pare, they immediately approached. But this petitioner, my lord, for the first time after the disposal of the case, my lord, he has approached. Only to that extent, otherwise it is squarely covered. But that can be, my lord. That can
I
be
don't
taken.
think he will be treated as a fence-sitter. Had he not approached the court at
Yes.
all, then he would have been a fence-sitter.
Yes.
No relief could have been
Yes.
granted. No relief would be granted. But here, he has already approached in 2014.
Paragraph 11 ର ମଧ୍ୟ earlier
All
writ petition.
After hearing, no, it is stated at the bar. No, in course of hearing, it is stated at the bar that the case of the petitioner is covered by the judgment of this court in Madan Gopal Nandi versus State of Orissa. The petitioner had also approached this court for the first time in the year 2014
14.
in WPC number
19,557
19,557 of
2014.
2014, wherein a favorable order was passed. Stop. Said order was not carried out.
Is there a list of overage candidate which has been prepared by the OPEP?
No, it's all right.
Or
Said order, wait. Said order was never carried out. You again approached in 2021.
21.
The petitioner approached this court again in 2021 in WPC number
Certificate.
ସେମାନେ ଗୋଟେ କରିଥିଲେ 7553 of 2020.
7553 of 2021, comma, which was dismissed for non-joinder of parties.
ନା ନା ସେଟା
Oh,
এটা হচ্ছে rejection of
সেটা
representation.
রিজেকশন হল
হ্যাঁ?
7553 of 21 filed by Sarath Kumar Rath and others,
Huh.
including present petition.
yes.
That has been rejected by the
No, there
opposite
was a
party.
direction to consider the repentation and the repentation was rejected.
Acha, how? And approach again, approach the 21, which was disposed of directing the secretary.
Rejection টা কি?
So rejected by the OPEPA,
Post-paper.
OP number 2,
The OPEPA
State Project Director.
to consider the representation of the petitioner and the other similarly placed
Right.
persons. Said representation was rejected. This writ application has been filed against that rejection. The present writ application has been filed challenging the order of rejection. In the meantime, this court in Madan Gopal Nandi Supra has dealt with the identical issue
Very same impute.
relating to the issue relating to similarly placed persons, wherein the rejection, the very same order in rejecting the representations of the petitioner and the said persons was considered. Said writ application was allowed with there is a direction to the last direction with the following directions.
11, 12, correct.
With the following observations. Yes. So, since the petitioner stands exactly on the same footing as the petitioners in the case of Madan Gopal Nandi and batch, the present writ application is disposed of. With direction to the opposite party authorities to issue order of engagement in favor of the petitioner for the post of Sikha Sahib / junior teacher schematic, as the case may be, against the unfilled vacancies without any further delay. Last time,
Item 8, challenging the disengagement order under Annex 3, my lord. The petition is Jugan Sahib, according to the year 2015, my lord. This order has been passed without any inquiry, without any given opportunity, nothing else, my lord. Thereafter, I have filed a declaration before the collector as to why the service of the petition has been terminated. My lord. The Sarpanch of the concerned Sarpanch, he has issued a letter to the video that there is no allegation against the present petition as a Jugan Sahib, my lord. Despite the fact that
no, the BDO has passed the order pursuant to order of the collector.
Collector.
So it is the collector, he has only communicated the order.
Yes.
So it is an appealable order, Mr. Kuntia. Appeal lies to the Director of Special Projects.
I have highly dependence on the answer for before the collector. That is pending before the collector. You will also direct to
No, how can when there is a statutory remedy available, why should they dispose of the representation? Why not? You can raise all the points, including the point of natural justice, violation of natural justice. When was this order passed? 24/5/2024. Still then, I will condemn the delay. When did you file this writ application?
Because in land of Koraput, my lord. So you
It is a case of Jogan, sir.
yes, Jugan Sahib.
Oh, Jogan Sahib.
Yes.
Not Gram Rose or
No, no.
Jogan Sahib te hele hobani bode.
There is the petition that the collector back as
Not absent.
All right. The petitioner who was engaged as Jogan Sahib of Bandhuga block by order dated 2/5/2015 of the Block Development Officer Bandhuka. So, while working as such, basing on the order passed by the collector on 24/5/2024, the BDO issued an office order of the same date on the same day, disengaging him from duties due to gross irregularities in distribution of PDS commodities and jute carry bags to the beneficiaries of Kaberibadi GP. So, it is the grievance of the petitioner that he was not given any opportunity of hearing, nor any inquiry was conducted to prove the allegations. Stop. Highlighting such grievance, the petitioner has approached the collector by submitting a representation on 12/6/2024, which appears to have been received by the collectorate on 13/6/2024. It is submitted that no action has been taken on such representation as yet. Stop. Since it is for the concerned authority to consider and dispose of the representation at the first instance, consider the representation at the first instance, the writ application is disposed of, directing the collector the collector Koraput to consider and dispose of the representation of the petitioner, if not already disposed of in the meantime, by passing a reasoned order and after granting opportunity of hearing to the petitioner. Stop. The representation should be disposed of within 2 months from the date of production of certified copy of this order by the petitioner.
Item 9.
In this case, the petitioner was an Anganwadi worker in Anganwadi Center since 2009. All of a sudden, in the year 2023, under Annex 1 page 8, an order was issued by the CDPO directing to hand over the charge to another Anganwadi worker of the Anganwadi Center. That I am reading with it. Consequent upon some allegations comes against Anganwadi worker of Anganwadi Center for irregularity of a GK spot for smooth functioning of Anganwadi Center. Baincha Dhya, Anganwadi worker Sabita Mahanta is remain in charge of Anganwadi Center with her own assignment until further. Thereafter, I have no scope to function as the Anganwadi worker in my Anganwadi Center, and the person assigned has discharged duty. Thereafter, under Annex 3, a common show cause notice issued in respect of several Anganwadi workers by the CDPO to submit explanation why you have not performed your duty, why you have not maintained records, and why you have not come to the Anganwadi Center. I have made explanation under Annex 4, page 12, that the good CDPO herself issued order of assignment and prevented me to work in my Anganwadi Center, though I am coming to the Anganwadi Center, but I am unable to maintain the record in view of the order under Annex 4. In the meantime, 1 month, 1 year, 3 months has been passed. I have not allowed to discharge duty. No further development, no modification order has been passed.
You take instruction. Learned State Council shall obtain instructions as to why the petitioner, despite being validly appointed as Anganwadi worker, has been prevented from discharging her duties since 26/6/2023. List this matter on 23rd October.
Item number 10.
That's over.
Item number 11, pattern matter.
Since last occasion, my lord, I must remember that my lord has directed the state government to take instruction whether joint inquiry committee has been conducted in presence of the petitioner.
You wanted to go through the
Yes.
file?
they have pointed me out that this is the joint inquiry.
No, what is the matter?
Matter initially she was a Anganwadi worker and till 93 she was appointed till 2008 just performed that duty with satisfactory to the utmost satisfaction of the authority concerned. And 2008 all of a sudden the villagers made allegation against me that I have committed irregularity. I am not coming to the department in the office. I am not properly distribute the foods amongst the children. So in view of that, inquiry was conducted as per Annexure 1. Annexure, on the basis of Annexure 1, I made answer to that effect. Your Lordship, kindly have a glance at Annexure 1.
Next one is that show cause.
Show cause, my lord, Annexure 2.
Yeah, what is it? Annexure 1 is a notice.
My lord.
Yes, then?
That joint inquiry.
And so far,
that
they
I'll
are
say.
regender, your Lordship will find.
No. What happened then? What happened then? Then you were disengaged.
Not disengaged issue notice. That has been stated by the Honorable Court. I went on appeal regarding the irregularity of issuance of notice against me. The learned collector set aside that order against the order of the sub-collector. Then it has remanded back to the sub-collector. Sub-collector again passed the order. Again, I went on appeal to the collector. Collector again passed the same order, and against that order, this present petition pending before the Honorable Court. And stay has been.
Initially, in the first order, the collector said that no opportunity was granted. In the second order, collector said that opportunities have been granted. Yes.
That is the joint inquiry as they have pointed out.
This is the case where Anganwadi worker, because of commission of serious dereliction of duties, was terminated. Evidence are available to show that inquiries have been conducted in presence of villagers, after which the termination was ordered. He has not considered the inquiry report at all. He has only held that inquiry has been conducted, therefore, you must consider whether the inquiry was properly conducted or not.
And if your Lordship will.
So this is a 2012 matter. Again, this court will, Mr. Behra, will this court sitting in a writ application enter into all this controversy? Inquiry ହେଇଥିଲା କି ନାହିଁ ଆପଣ କେତେ ଚାଉଳ ଆଣିଥିଲେ କେତେ ଚାଉଳ ଦେଲେ କେତେ ବାଲାନ୍ସ ରହିଲା ମୁଣ୍ଡା ରସିଦ କୁଆଡେ ଗଲା ଆପଣ ତାଲା ପକେଇ ସେଦିନ କୁଆଡେ ଯାଇଥିଲେ ପିଲାମାନଙ୍କୁ ଅଣ୍ଡା ଦିଆଗଲା ନା ନାହିଁ କ୍ଷୀର ଗୁଡା ଆପଣ ସେଠିକି ଅଙ୍ଗନୱାଡି ସେଣ୍ଟରକୁ ନେଲେ କି ଘରକୁ ନେଇଗଲେ ଏ ସବୁ ଏଇନା ହାଇକୋର୍ଟ ବିଚାର କରିବ କିଛି କିଛି ମୁଁ ପଠେଇଦେବି କଲେକ୍ଟର tell me the collector says
Have a glance.
evidences are available to show that inquiries have been conducted. Had the collector written that there is evidence to show that the allegation against the petitioner is correct and has been proved by the inquiry, then I would have confirmed the order or whatever. Inquiry ହେଇଛି ତେଣୁ ଗୋଟେ ଫକୀର ମୋହନ କୁହନ୍ତିନି ଫକୀର ମୋହନ କୁହନ୍ତିନି ଯହୁଁ ବୁଝିବ ରାଜକନ୍ୟା ତହୁଁ ବୁଝିବ ସୁନ୍ଦରୀ ସେଇ ଭଳିଆ ତେଣୁ ଇନକ୍ୱାରି ହେଇଛି ମାନେ ସବୁ ଠିକ ହେଇଛି ଆଉ ହବନି ହବନି ନା Mr. Behra, I'll set it aside, I'll send it back again to the collector. Let him consider the inquiry, joint inquiry, whatever is there material on record, let him apply his mind. He is the collector, after all, he is the appellate authority. Collector to jiba katha nahi, jiba katha ADM ko pagu.
Regender, the Lordship will finds from the regender, there are B/4. It has been clearly mentioned that the food committee has established and they have.
So let him consider that. Let him take into consideration. He will grant you opportunity. He will produce all materials. He will consider it.
2015 ରେ କଲେ ତାପରେ 2009 ରେ ଆସିକି
I know. This court is fully conscious that this court is constrained to pass this order. Otherwise it will be entering into a completely factual controversy which is not maintainable. Your writ petition would not be maintainable at all. Certiorari କରି ହବ କି quasi judicial authority କେମିତି କରିବେ ଆପଣ କୋନା?
Let the collector find out factually and give specific finding.
Yes, learned state as directed, Learned State Council has produced the inquiry file. A joint inquiry has produced the original file containing the joint inquiry report.
Joint inquiry nahi.
Some documents are available in the case record. Say dita page xerox copy. Epot original, separate original, majority xerox copy. Case record to show that the matter was purportedly inquired into in the presence of the villagers. Stop. There is nothing on record to show as to if the petitioner was given any opportunity of hearing during inquiry. Stop. Reading of the impugned order shows that the collector has simply held that evidence is available to show that inquiry has been conducted in presence of villagers, after which the termination was ordered. Stop. It is evident that the collector has not applied his mind to the materials and evidence on record. Stop. In other words, the collector does not appear to have considered whether the allegations leveled against the petitioner were actually proved in the so-called joint inquiry. Stop. Moreover, though the collector has held that the sub-collector has given adequate opportunity to the appellant, yet fact remains that the so-called inquiry appears to have been held without any opportunity of hearing being granted to the petitioner. Be that as it may, the matter having been remitted to the collector for fresh disposal in accordance with law, it was incumbent upon him to take into consideration all the available materials and evidence and documents on record to be subjectively satisfied as regards the veracity of the allegations leveled against the petitioner. It is trite law that a person cannot simply be thrown out of employment on allegations, which first need to be proved by applying the principle of preponderance of probability before any action can be contemplated against him. This is a case where an order of disengagement was passed, thereby affecting the right to livelihood of the petitioner, which is otherwise guaranteed under Article 21 of the Constitution of India. Stop. This court is conscious of the fact that the impugned order was passed on 25/1/2012, and more than 12 years have elapsed in the meantime. Stop. But then, this court, sitting in writ jurisdiction, would not be in a position to make a roving inquiry into the factual aspects to determine the guilt or otherwise of the petitioner. So, there is thus no other option than to remit the matter to the collector for fresh disposal. Stop. In the result, the writ application is allowed. Stop. The impugned order under Annexure 9 is hereby quashed, is hereby set aside. The matter is remitted to the collector, Hon'Ble, to consider the appeal of the petitioner afresh, after independently applying his mind to the relevant facts and materials available on record, and after granting proper opportunity of hearing to the petitioner. Stop. it shall be open to the petitioner to produce all necessary evidence in support of his content, her contentions, which, needless to say, shall be considered in the proper perspective by the collector. Since this is a case of the year 2012, the collector shall do well to dispose of the appeal finally as early as possible, preferably within a period of 4 weeks from the date of production of certified copy of this order. The original file be returned to the State Council. Sir?
Unless until
Since the petitioner has been continuing as Anganwadi worker on the strength of interim order passed by this court, she shall be allowed to continue till disposal of the appeal. And thereafter, depending on the result of the appeal.
Passing of the impugned order at present will not give the petitioner a handle to claim the statement or to, it is left open to the authority.
No, I said till disposal of the appeal, she'll continue. And thereafter, depending on the result of the appeal.
Right.
If the appeal goes in her favor, Mr. Das, if the appeal goes in her favor, she will continue.
Yes.
If it doesn't, then she'll come to this court again. Yes.
I don't know, 12.
Well, in this item number 12, my lord, with respect to that Noyagod issue, the death of 7 children.
Yes.
Due to collapse of office.
Hmm.
I had discussed with the authorities and I was directed to take the instruction with respect to the specific government that the headmistress of that particular school did not allow the Anganwadi center to operate. So I need some time, my lord, to get that particular information. Next week, it will be sufficient. I have already discussed with them.
Next 8 May can leave class. Yes, next the headmistress what intimated to the video.
No, I have already checked that, my lord. I have already checked that.
Document they have produced. Suasai, headmistress Suasai, Sarkaranga Nirdesh Mutabaka, Suasai Sai School, Gote Bokra, Anganwadi, Suasai, Godam Sai, Anganwadi Center ku କରିବା ପାଇଁ ନିର୍ଦ୍ଦେଶ ଥିଲା କିନ୍ତୁ BRCC CRCC ମନା କରିବାରୁ ଆମେ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ଘରକୁ ଦେଇନଥିଲୁ. It is their own argument. That was reflected in the counter affidavit by the collector.
But after going through the same, it was directed to.
If he wants only one chance, I will grant it to next week. We will dispose of it. We'll dispose of it.
Next week.
You see, on the last occasion, I remember Mr. Mahanti had said that the incident is very unfortunate.
Yes.
Some children died.
Yes.
Everybody is shocked and surprised, and our sympathies are with them. The person cannot be removed from service like that, just like that, if she has no role to play in the matter.
Well, that is what I was thinking. But after going through the papers, it is something else.
Well,
so I will produce it.
We'll pass a judgment. Yes, whatever. We do not know. The writ application may be allowed, may not be allowed. How to know? As requested by Learned State Council, is this matter next week?
Published.
13.
Lords, the last occasion I had drawn the Lordship's kind attention. The approval was rejected applying the principle Lords Rule 74. Lords, I had demonstrated to Lordship on the last occasion saying that Rule 74 is not applicable.
Mr. Bhanti, just a moment. Justice Nursing appears to have passed a very detailed order. Let me go through that order. I think it will be better to understand. The resolution file assigning the order at Annexure 11, by which the approval of the petition of the headmaster in Sankar's UP school has been declared since the same is in violation of Rule 5.1 of the rule. Yes.
Lords, therefore, the first time they raised this allegation that without seeking prior approval, I have been appointed. This is the only allegation again. And second, say that since it is a matter of approval, instead of coming to this court, I should have approved the execution tribunal. Plus, my respectful submission to this aspect, plus two judgments I will cite to Lordship. One, Honorable Supreme Court, other the division bench of this Honorable Court. The two decisions, my lords, say, our High Court say that when the matter is pleadings complete and a matter is for hearing, at this stage, the party should not be.
No, if it can be disposed of on the basis of materials on record. But without making any further inquiry, if it can be disposed of on the basis of materials available on record without entering into any factual controversy, then that is the law. I have also decided one case, probably Mr. Samir Das was arguing that matter. So what is the matter here now? What is the point here?
So only point is my approval has been rejected, page 26, annex 11. That two grounds they have taken. That appropriate authorities, the MC without taking prior approval of the appropriate authority, it is ab initio illegal, void because appointment has been made without following the procedure prescribed under 5.1 sub-rule 8.9 of the recruitment rule 1974. This has been repealed since 1992.
But there is a provision, rule 8.
8 is the exception and is also applicable to 74 rules. This is, lords, with regard to that 1974 rules. Lords, they notified the school and it is applicable with effect from 1/5/2008. My appointment is 23rd April 2008.
No, when you were appointed at a time when Rule 5 was in operation.
Rule 5
was in the statute book. It had not been repealed. That is what they are saying.
Lords, in my that was repealed, Lord. By
it was repealed. Yes, it was repealed. When were you appointed?
Lord, they 23rd April 2008.
2008. So it was repealed. Rule 427 repealed by Odisha. No, that was in 1992. So thereafter, when you were employed, Rule 8 will come into picture. It says, notwithstanding anything to the contrary in these rules, it shall not be necessary to apply to or submit any appointment with management. If the appointment is made on ad hoc basis for a period not exceeding 3 months, or the vacancy in a post carrying higher scale of pay is filled up with prior approval of government in case of a college. So, exceptions to selection by the board. So,
my appointment was
by the managing committee. It must have been by the managing committee.
Managing committee, the post.
So you to be able to take the benefit of this exception, these two conditions are there. The appointment must have been on ad hoc basis for a period of not exceeding 3 months. 3 months mein college darkar nahi. Now, if it is a higher post, not an assistant teacher but a headmaster, then prior approval of the concerned authority.
My respectful submission is 74 rule is not applicable because my school has not been notified.
At that relevant time?
Yes.
When you were appointed as...
yes.
Say that. That is a different matter.
This is my case.
So what will be the effect of... when was it subsequently? When did it come under the granted fold?
1/5/2008.
After that...
After my appointment.
Achha. So will it have any retrospective application?
And the counter affidavit, since the only ground taken was 24B. Now the latest instruction received is that he is not attending.
That's a different matter. The question of withdrawal of approval of the appointment as headmaster.
Yes.
When he was appointed as headmaster, the school was not an aided school. So 74 rules and the Education Act doesn't apply at all.
Not apply then.
What will be the effect of coming into force of the... So there has to be a post facto approval, obviously. It's already been... So the question of prior approval will be relegated to the background. So there can only be a post facto approval. And post facto approval, if I remember correctly, probably there was a recommendation.
So what has
Was there a recommendation?
Series of
Series of recommendations. So this aspect probably has not been considered.
So recommendation has been made to the director for approval. But it has been said in the latest instruction of 20th of August that she is not attending nor she is performing her duty.
No,
That is subsequent.
I am discharge duty.
No, no.
Yesterday I have
ଆପଣ ଆଉ ଗୋଟେ କୋଉ matter ରଖୁଛନ୍ତି କି?
ନାଇଁ,
ଆଚ୍ଛା, ସେଇ ଶ୍ରୀଦେବ ମହାପାତ୍ର ତ?
sir.
Because it has already been rejected. Come to Annex 11.
Instruction.
I am that to say that since the appointment has been made by the managing committee without taking prior approval of appropriate authority. Now the question is, at the relevant time, there being no, it not being an aided institution, the question of taking approval of prior
Then
authority.
it was not required.
So once the school comes under the grant in aid fold, then post facto approval will be done.
So what has happened with the director, that is now the question.
No, they have rejected it. As such, the appointment order of appointment is non-est in the eyes of law. You cannot retrospectively apply the rule to a situation when to a time when the school was admittedly not an aided institution. No, institution means an educational institution as defined in section 3E of the Act.
Yes.
Institution as per the Act, or the rule rather.
Yeah.
There is a subsequent clause, Mr. Mahanti, I had pointed out the last occasion also. In clause B of subsection 1 of section 8, rule 8, sorry. Such appointment shall be treated as a regular appointment. From the date, the same is filled up on ad hoc basis by the managing committee or the governing body as the case may be, in the event of its approval by the competent authority. So this postulates a post facto approval. Isn't it? This aspect has not been considered. This will be read with A, not B, even though it is placed in B. In one of my judgments, I have decided that case. I think probably Mr. Kunal Swai judgment in your case. Yes, Mr. Swai. He may not be aware, but the senior was conducting that case. I have referred to a particular maxim,
I will check.
redendo singula singulis, which means the particular statute must be considered in the context of the existing statute. So, it should be understood to mean wherever it is appropriate. Here, even though they have placed it in clause B, it should have gone to actually clause A. Because clause B simply says about prior approval. You may please examine that judgment.
My Lord Justice, Honorable Chief Justice, Honorable Hansaria, if his lordship's judgment is also there, prior post facto approval is permissible in case of appointment. That is the judgment.
Justice R.K. Patra's judgment is also there. But that was under section rule 5.
But the
Interpreting rule 5.
The question is post facto. In this case of the two approvals, prior approval in case of termination, post facto approval in case of appointment. So
I'll give you the citation of that judgment, the reference. Please find out. I don't know whether it will be applicable or not, but the same thing.
well,
Here, the position is very clear. It was not an aided educational institution within the meaning of the rules. So you cannot apply the rules. The only thing that can be done is granting post facto approval. So please consider. So, what further arguments in part? Let's this matter next week. Next week, next week. In the meantime, please.
I will collect.
Yes. अरे कितने अजी पाठ की छोटा अरे बाबा
I do know 14.
Two transfer.
judgment. Yes. Oh, Didi. Two judgment again. Two judgment. Oh, see you. Yes. Did you see that judgment?
Yes, your lordship.
Have you seen it, Mr. Godi?
ଗୋଟେ କପି
ଆପଣଙ୍କୁ ମୁଁ ଆଉ ଥରେ ପୁଣି ଆର୍ଜନ କରିବି କଣ ଏଇଟା ଆପଣ ଦେଖିଦି ତାଙ୍କୁ ଗୋଟେ କପିଟେ ଦେଇଥାନ୍ତେ
ମୁଁ ଗୋଟେ ଦେଇ ଦଉଛି ଏବେ।
detailed judgment has to be passed. I'm closing it.
Another two judgments I have given, my lord.
Please. You do one thing. I'm closing it. You file a note along with all these judgments.
And another two
Anything, Mr. Gode?
My lord, in this case, the 377, the judgment order reveals that the respondent wife has appeared on dated 18/4/2023, my lord, and the judgment has passed on 4/4/2024, my lord. In the meantime, the respondent wife could not take steps as well as did not file the WS. For the after 1 year, the
I'm not saying that I will allow the transfer. I'm not saying that. I may allow, I may not allow. So I will go through the transfer application. If I am convinced, then only I will allow. But the question is, what will happen to that
judgment.
judgment? Alright.
During stay period, actually it is passed.
Yes. So this court which had stayed it, being the superior court, can always pass that order. You have to ignore that judgment. This is the law. All right. Hearing concluded, judgment reserved. Parties may file their note of submissions and memo citations, if any, within a week. Have you taken it back, Mr. Mahapatra? Have you taken back the judgment?
Yes, the three judgment I have.
You also go through.
14, 15, both are same. One is section 9, one is section 30.
All right.
I don't know, 16. 16 is also in my case. In fact, my lord,
I am the petitioner in the second connected case. Mr. Mishra, my lord, senior is the petitioner in the first case. He is in virtual mode.
Yes, Mr. Mishra. You have to unmute. Please unmute yourself. Yes. No, Honi. No.
He has to rejoin.
Hmm?
He has to rejoin, probably.
ଆପଣଙ୍କର muted ହେଇକି ଅଛି. Now there is some problem, so rejoin କରନ୍ତୁ. ବନ୍ଦ କରିକି ଆଉ ଥରେ rejoin କରନ୍ତୁ.
thank you.
What is this matter?
But this is a matter relating to appointment of permanent worker. Let me draw your lordship's attention towards the counter filed by the state.
In the first case?
In both the cases, one center is there, madam. Two applicants have filed. First, I indulge your lordship's attention towards the counter filed by the state in WPC number 16157 of 2022.
Yes.
Page 9, madam. This was a notification dated 21/1/2010, inter alia directing to file the applications on 4/4/2010. That is the photocopies of the documents as desired in the advertisement. And if a lordship will come to below, स्थायी बासिंदा प्रमाण पत्र एक सत्यपात नकल जहाँकि एही विज्ञान प्रकाशन पूर्व 6 मास मध्य संपृक्त अधिकारी विज्ञान 6 मास पूर्व मिलता आवश्यक. Lordship got it, man?
Yes.
Then your lordship kindly come to খ গ গ খ মাইল গ প্রার্থিনী হরিজন আদিবাসী হইলে প্রার্থীকে অধিকারী প্রাপ্ত প্রমাণপত্র একত্রিত সত্যবাদ নকল প্রার্থনা করিবে প্রার্থিনী ভিন্নক্ষম হইলে সম্পৃক্ত প্রার্থিনী পিতৃমাতৃহীন হইলে সম্পৃক্ত অনুষ্ঠানରୁ আবশ্যক প্রমাণপত্র দেবে দেন প্রার্থিনী নিঃস্ব পরিত্যক্তা হইলে প্রার্থীকে অধিকার প্রমাণপত্র দেবে then my lord, these are the conditions for which they have categorically and consciously stated that the certificate should be within 6 months prior to the date of advertisement. Only to consider these aspects, the authorities have put this condition that the certificate should be produced, which is given by the competent authority within 6 months, prior to 6 months from the date of the advertisement. Then you'll also kindly come down to the next page, page 10. Just let's look at tab 5/2/2010 ପୂର୍ବରୁ 10 ଘଟିକା ସମୟରେ ସମସ୍ତ ଆବେଦନକାରିଣୀ ସେମାନଙ୍କ ଦରଖାସ୍ତ ଦାଖଲ କରିଥିବା ପ୍ରମାଣପତ୍ରର ମୂଳନକଲ ଆଣି ନିମ୍ନ ସ୍ୱାକ୍ଷରକାରିଣୀଙ୍କ କାର୍ଯ୍ୟାଳୟରେ ଯାଞ୍ଚ କରାଇ ନେବେ এই ଯାଞ୍ଚ କାମ ଚାଲୁ ରହିଥିବା ସମୟରେ ପ୍ରାର୍ଥୀ ଧାଡିରେ ଆସିବ ସତ୍ୟାଂଶ ଛାଡି ସ୍କିପ୍ ଇଟ୍ ଏ ସମ୍ପର୍କରେ ତାଙ୍କର କୌଣସି ଆପତ୍ତି ଅଭିଯୋଗ କରାଯିବ ନାହିଁ 6/2 look at on 6/2/2000 ପୂର୍ବାହ୍ନ ପ୍ରତିମାନଙ୍କ ତାଲିକା ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରରେ ପ୍ରକାଶ କରାଯିବ ଏବଂ ଏହି ଦିନ ଠାରୁ 12/2/2010 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ ସର୍ବସାଧାରଣରୁ ପ୍ରାର୍ଥୀର ସ୍ଥାୟୀ ବାସିନ୍ଦା ଶିକ୍ଷା ଯୋଗ୍ୟତା ଏବଂ ଜାତି ସମ୍ପର୍କିତ ଅଭିଯୋଗ ଗ୍ରହଣ କରାଯିବ 19/2/2010 ପର୍ଯ୍ୟନ୍ତ ଅଭିଯୋଗ ଉପରେ ତଦନ୍ତ କରାଯିବାର ବ୍ୟବସ୍ଥା ରହିଅଛି ଏଣୁ ପ୍ରାର୍ଥୀ ମାନେ ଏହି ସମୟରେ ନିଜ ଗ୍ରାମରେ ଉପସ୍ଥିତ ରହିବେ ଯାଞ୍ଚ ସମୟରେ ଅରିଜିନାଲ ପ୍ରମାଣପତ୍ର ଯଦି ଭବିଷ୍ୟତରେ ଭୁଲ ପ୍ରମାଣିତ ହୁଏ ସେଥିପାଇଁ ସେ ପ୍ରାର୍ଥୀ ଦାୟୀ ରହିବେ ଯାଞ୍ଚ ସମୟ ମଧ୍ୟରେ ଯାହା ପ୍ରମାଣପତ୍ର ଦେଇଥିବେ ତାହା କେବଳ ଗୃହୀତ ହୋଇ ପରବର୍ତ୍ତୀ ନୋଟିସରେ ଯାଞ୍ଚ ପାଇବ ଯାଞ୍ଚ ପରେ ଅନ୍ୟ କୌଣସି ପ୍ରମାଣପତ୍ର ଗ୍ରହଣ କରାଯିବ ନାହିଁ This is an advertisement dated 21/1/2010. Look at the below the signature of the CDPO. Sishu Vikasa Prakalpa Adhikarini. So admittedly on 4/2/2010, the petitioner could not produce the photocopy of his caste certificate, of his residential certificate. On 5/2, when the verification was made, she had filed the application. Lordship now forget it. Now Lordship kindly turn to next page of the counter. I'm bringing you Lordship kindly to page 13. That is dated 22/1/2015. No selection was made, no objection was made within the time stipulated as stipulated in the advertisement by any of the candidates. This is my first submission. No selection was made till 2015. No connection, it was kept in record. Then you logically turn to page 14. Serial number 9 is Hatta Dobandha. Let's kindly turn to page 14. Hatta Dobandha. That is also in the year 2015. Then you will also kindly turn to next page, page 15. ଏତଦ୍ୱାରା ସର୍ବସାଧାରଣଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି କି ଉକ୍ତ କାର୍ଯ୍ୟାଳୟର ପ୍ରାର୍ଥୀଙ୍କର ସତ୍ୟାଂଶ ତାରିଖ ଅନୁଯାୟୀ କର୍ମୀ ନିମନ୍ତେ ଆବେଦନ କରି ପ୍ରାର୍ଥୀମାନଙ୍କର ଗତ 14/1/2015ରେ 15/1/2015 ତାରିଖରେ ଦରଖାସ୍ତ ଗୁଡ଼ିକ ଯାଞ୍ଚ କରାଯାଇଥିଲା ଯାଞ୍ଚ ପରେ ପ୍ରାର୍ଥୀମାନଙ୍କ ଦରଖାସ୍ତ ସମ୍ପୂର୍ଣ୍ଣ ବିବରଣୀ ପ୍ରକାଶ ପାଇଲା ମାତ୍ର ଉକ୍ତ ବିବରଣୀ ପ୍ରତି ଯେକୌଣସି ଆପତ୍ତି ଅଭିଯୋଗ ଥିଲେ ବିଜ୍ଞାପନ ଦିନ ଭିତରେ 22/1/2015 ମଧ୍ୟରେ লিখিত অভিযোগ প্রদান করিবে that is dated on 16/1/2015. This is the letter. Then you will also kindly turn to next page, page 16, my lord, of the counter of the state.
Yes.
Basanti Sahu, I serial number 1, who was the appellant before the ADM, does not belong to the area in question. Let's look at it, that is Koma Sasana. The center is Hatto Dobandha, because there is already school in Kamasasana. So she filed the appeal in the year 2016 against my appointment. Then your lordship can turn to page 17. This is verified. That is also dated on 3/11/2015. Lordship, look at only, I indulge your lordship attention the dates. Date of inquiry, 3/11/2015. Pratima, during inquiry, it is found that the following candidates are resident of the service of such and such. Pratima Panda, Hatadiya, such and such is Hatadiya, Basanti Sahu, lordship, look at Malad, Sasana. Last number,
Yes,
who
yes.
is the appellant, who was the appellant before the
Yes.
88. Then, my lord, the disengagement order was on 25/8/2022 and at page 18. Now I have filed an additional affidavit which has not been answered. Additional affidavit I have filed, my lord, which has not been answered in the month of August 2024, either by the state, despite the lordship's direction. Let's take a look at the same thing as I have already read, 21/28/11/2005. Then the villager signature, that is dated 24/2016. Then your lordship can turn to next page. Again, I have already read. I am a graduate and a SC candidate, my lord, and I have secured the highest marks. Then your lordship kindly turn to this next page. The marks and inquiry was conducted, and then your lordship kindly see the page 12, my lord. Once again, I have given my caste certificate in 2015. I'm sorry, yes, my lord. Residential certificate. Page 12, annexure 9 to the additional affidavit. Neither the appellant nor the next petitioner has ever filed any certificate in the year 2015. Then your lordship kindly see that was an inquiry by the Tahsildar sub-collector, wherein it is categorically decided that Basanti Sahu does not belong to the area in question. That is page 13, annexure 10 to my additional affidavit. Then, my lord, next page, page 14, I have already shown your lordship, my lord. CDPO, Tahsildar, Block Development Officer. So far, the appellant is Basanti Sahu, does not belong to the area in question. Now they are raising a question that since I had not submitted the photocopy of this residential certificate on 4/2010, therefore I have not entitled for consideration in terms of the advertisement of the year 2010. So now my first contention with your lordship is, if your lordship will read the advertisement, the very purpose of the advertisement is that the area persons should be allowed to continue as the Anganwadi worker. Those will secure the highest marks. But when there was no selection, no objection in terms of the advertisement, when the selection or the verification was made in 2015 and I was appointed 2016, whether such a plea can be sustainable, because I had not submitted an application on 4/2. That is my humble submission to your lordship. I have nothing to submit. If your lordship will permit, I will file. Because my entire contention is, when you are doing an appointment or a verification or selection in the year 2015, none of the, neither the appellant, I mean to say the opposite partner 6 in the my writ application, nor Pratima Panda has filed any document that they have filed any certificate, especially the residential certificate in the year 2015. Therefore, the advertisement 4/2010 cannot debar me for consideration, even if it will be within the person those who have applied. And I have submitted my residential certificate once again in 2015. That only on account, because otherwise the very purpose of 6 months prior to selection is will be futile.
Yes.
That is my limited submission. I will file a 2-page note Lordship may consider my submission, and my categorical submission with your Lordship is, if your Lordship will look at your Lordship previous order, your Lordship categorically directed the state government to examine the additional affidavit, which I have filed, that neither of the parties have made any objection or anything. And my category and second submission is that the appellant before the ADM is not a resident of that area. That's all, my lord.
Yes.
The state will argue first or I am the opposite party number, my lord.
Your lordship will permit whom to submit. Well, the only clarification I am just bringing, my lord. So far as the client of Mr. Mahapatra is concerned, he was the appellant before the Anganwadi in the Anganwadi appeal. I am the petitioner in the second case, and my lord, I am also an opposite party in the present first case by virtue of the application for intervention. I am OP number 7 there. On the other hand, challenging the very same selection, my writ petition has been kept pending before this honorable court since 2016 after issuance of notice immediately after the selection was made. Prior to the present writ petition which I had filed, I had also approached the honorable court when the very candidature of this the petitioner of the first case was accepted, even if it was per se ineligible. In that application, this honorable court directed the authority to consider my objection and representation, which was never considered, and rather they were technically rejected it, saying I had not complied with as per by making my application within the 15 days within the time stipulated by this honorable court, which I am also disputing by filing applications under RTI, which clearly reveals that not only I had complied, I had within the time stipulation, I had made my application, and after that again I have approached when the selection was completed and the appointment was made. This is the backdrop. So your lordship may permit whom to submit before lordship.
First writ application, my lord and senior has argued.
No, but in that case also the state council was directed to take instructions with regard to the additional affidavit, which he was just now placing.
Yes.
But in additional affidavit, no new point has been raised. That is exactly the same point, whatever is there pleaded, and government has already answered. He has not taken any new thing. Well, rather, if your lordship will find in the writ petition, whatever.
So let the state say that.
Yes.
Let the state say that. I'll accept it.
Yes.
If the state says that there is nothing.
Counter affidavit filed in both the writ petitions, the state has no further say in the matter.
But what is the stand of the state?
Stand is that the residence of the opposite party number 5 is not within this
writ
petitioner. In the first writ petition, paragraph 11, your lordship may kindly come.
But she belongs to Hatta
No, there, your lordship, one thing, my learned senior has probably not aware, or he has not gone through the file properly. But the advertisement in question was in respect of Hattodomadha and Komasasan. That my learned senior is probably missing. Your lordship,
So even accepting that,
she belongs to Komasasan. So he is an eligible candidate.
and he belongs to Hatta
She doesn't have this residential certificate of Hattodomadha.
This is not a point here, my lord, to decide who belongs to in which place. Fact remains that the last date of submission of application is 4/2/2010, and admittedly, what has happened, and one residence certificate was issued by the Tahsildar in favor of opposite part number 6 on 5/2/2010 after the last date of submission. That residence certificate doesn't show that she belongs to the Anganwadi center area. Therefore, it is subsequently modified on 19/2/2010, adding Hattodabandha in that term. So, point is here whether after last date of submission.
No, anyway, Mr. Mishra has the senior counsel has made his submission. State, I don't think you have anything further to say.
Beyond the counter affidavit that have been filed, we have nothing more.
Anyway, so you will make your submissions. We'll continue next week. Judgment.
My one answer would be, my lord, that Mr. Mahanti has not read that the advertisement perhaps that it is a left side of Komasasana school. Komasasana, that is a school in Komasasana itself. So the appellant has no
It is disputed
jurisdiction to
fact
file an
and
appeal.
it will
My-
not be dealt
And
with.
that has to be
My lord
answered
and
by
senior was
the
referring to
It is a disputed
page
fact.
9.
It can't be dealt with.
He escaped page 11. Your lordship,
I will go through, I will go
the
through.
very counter.
No, he has made his submission, Mr. Mahathi. He has made his submission. You will make your submissions. That's all.
Yes.
Mr. Mahapatra and you,
So
you
my-
continue on the next week.
Yes.
So the state council, I think nothing further remains to be argued on your behalf. All right.
Only we
I'll
will
keep
argue,
it.
your lordship.
Heard further arguments.
Point more.
Heard further arguments in part. Is this matter kebu kariyo? Next week of na nahi hoban. Chata hi rani. Tinta hi. Oh, wait. Next week.
Okay.
Mr. Mahapatra, next week.
My lord, diplo.
I don't know, 17. The item 17, my lord, the petitioner challenged the advertisement of 2010, my lord. So the matter has become, my lord,
Infructuous.
no instruction.
No instruction disposed of. Amarja order. Huh? No instruction disposed of.
I don't know, 18.
You are appearing.
I am for the opposite part, no further.
Yes, item 18.
May I please, your lordship? Lordship, taken over next.
Senior counsel, Mr. J.K. Rath is at his legs. He's leading this matter
Is on his legs, not at his legs.
on his legs. Sincere apologies.
No, don't have to apologize. Don't have to apologize. We'll not pass it over. We'll adjourn it. Next week.
I don't 19.
Adjourn next week as paid for. The 11 comes with the petition.
My lord, pray for 1 week time.
Kar diyo. Place this matter on 23rd October as paid for.
Interim order to continue.
Interim order to continue.
I don't know, 20. May I please, your lordship? That the petitioner having BSc qualification was appointed against an additional 10 graduate post on 4/7/1991 by the managing committee of the school, my lord. My lord, his appointment was confirmed by the committee, managing committee by resolution dated 31/7/1991 under Annex 2, my lord. The managing committee.
Officer appointment Tapaswini Acharya, BSc, an outsider is appointed as an assistant teacher of the school against supra post. In the usual scale of pay. गला तापरे अपॉइंटमेंट 2 रे कोन हला ए annex 2 रे कोन हला resolution.
Yes, my lord.
Hmm.
The appointment of the petitioner was confirmed by the managing committee by its resolution dated 31/7/1991 under Annex 2. Then the managing committee of the said school passed a resolution on 23/7/1996 recommending the case of the petitioner for approval of her appointment under Annex 5, my lord. When the proposal was pending before the Director Secondary Education, in the meantime, one Sandhya Rani Lenka, my lord, the assistant teacher of the said school whose services had already been approved, was transferred to some other school, and as a result of which vacancy arose in the same school. And while the petitioner made a representation to the management to adjust him against this said post, my lord. Thereafter, my lord, the managing committee of the school, my lord, recommended for approval of his post, which is pending till today, my lord. And in the meantime, my lord, the additional section teachers of the state, my lord, were terminated by a common order dated 24/2020, my lord. My lord, the ground, my lord, for which this appointment was not approved is that he was not having the B.Ed qualification.
Where is that order?
My lord,
Where is that order rejecting your application for approval?
no, they have not rejected. No
Then-
formal order has been passed.
Then
No formal order has been
Then-
passed, my lord. But for
what will this court decide now?
my lord,
What will this court decide, Mr. Swami?
with all the additional section teacher, my lord, who are containing throughout the state, my lord, all their services have been terminated by the common resolution under the common resolution dated 24/2020. My lord, they approved this honorable court and the tribunal by filing a writ petition, and several OAs were filed before the tribunal, my lord. In one case, particularly Vivekanand Das case, my lord, where the honorable High Court has held that even if a untrained candidate, untrained teacher can be appointed against a 10 graduate teacher post, and he will continue to get the untrained scale of pay.
No,
my
but
lord,
what happened to in your case? Were you terminated?
yes, my lord, I was terminated.
Then
I was terminated, but no formal
you
order.
have not amended your writ application since then.
My lord,
You have not amended your writ application? Unless you are reinstated,
Yes,
the
my
question of granting you untrained scale doesn't arise. As things stand,
Yes, my lord.
how can we go back to the previous position when you yourself admit that you have been terminated in the meantime
Yes, ma'am.
during pendency of the writ application? So yes, Mr. Patnaik,
Yes, ma'am. My lord, the case is something different, my lord.
that is what I
As it
find
is
also.
present.
That
Yes.
is what I find.
Actually, my lord, initially she was appointed against a post of assistant section teacher.
Hmm.
That's Supra.
Hmm.
That was in the year 1991.
Hmm.
Our first time, my lord, that she completed her study, my lord, in the year 1992
Hmm.
as a regular student. And thereafter, my lord, the training in the year 1996. But whatever that may be, my lord, thereafter, she filed a case in the year 1998. All the persons were terminated from the services, my lord, in the year 2000. I think, my lord, that's a common order, my lord. Thereafter, my lord, she didn't approach anywhere. She didn't file any case. Others have approached before this honorable court, and thereafter the decisions were taken, and those decisions were persons counsel, my lord. But this petitioner, my lord, in the meantime, she accepted the appointment in another school as a headmistress. She suppressed that particular fact in the writ petition. Then we disclosed the same, saying that this petitioner had already been absorbed and her post has already been approved since 2006, and she is getting the admissible pay under the block grant.
जोड़ा annexer E/3 series को लिख दीजिए. That is what I was looking at.
So, my lord, now she is not disputing all these things. She is saying that I am interested to leave this particular post, but you approve me from that particular.
My lord, I was appointed.
So that approval, there is a gap
Yes.
because she was terminated
Yes.
in 1996.
I think, my lord, that is the date.
Hella, she was
Yes,
terminated.
2000, my lord.
2000, my lord.
So as on 2013, when you filed this writ application, Mr. Swami, you were never employed.
No.
You were dismissed or terminated.
Yes, terminated.
Sarla.
Well, I was employed in another school in
Maybe,
2003.
maybe,
Email ID 2003.
maybe, unless that termination order is set aside. So will it not stare at your face? So subsequent appointment will be a fresh appointment. It is in fact a
yes.
fresh appointment.
Yes.
Khatam. Khel khatam.
My lord, I will amend my.
Khel khatam.
Well, that termination order has to go first, my lord.
ବୁଝିପାରିଲେ ନି ଖେଲ ଖତମ ମାନେ
Unless.
ଖେଲ ଖତମ ମାନେ ଆପଣଙ୍କର ରିଟ୍ ପିଟିସନ ଗନ୍ ଏଇ ମୁଁ ଡାକୁଛି କିନା ଅର୍ଡରଟା
Unless that termination order goes, my lord, I have no case. Your lordship is absolutely correct, my lord.
so and termination order, even if supposing I permit you to challenge that order was passed maybe 20 years back.
Yes, my lord.
Still claim कुछ नहीं होगा.
Well, similarly situated persons who are terminated along with the petitioner, they approach the honorable tribunal, honorable High Court, my lord. They have got an order in their favor and they have been.
Reinstatement.
Yes, my lord.
You did not. You slept and you looked at greener pastures, as the saying goes. You looked at greener pastures and you have also been benefited by being appointed in that Jagdalpur. कौन सिद्धेश्वर UP school Jagdalpur under Gorakhpur block में तो कुछ ऐसा खोली रखी पड़ा.
I was appointed after 3 years of termination.
Maybe 2003. And it is said that school has been recognized, the terms and conditions wala.
And she is receiving the block grant, my lord.
They received.
Managing company the school is hereby approved subject to condition that they shall not claim any GIA from the state government. Set up करछि तापर GIA भी पाइथिबे.
Well, if I will be reinstated over here, I will get a larger benefit, my lord.
हवनी.
If your lordship permits me, I will file that.
No,
amendment.
it's not a question of not permitting or not permitting you. It's a question of what will be the scope of this writ application. You cannot enlarge it.
Yes.
You cannot enlarge it.
Next week, sir.
No. You have to.
Well, next week.
You are a young counsel, Mr. Swami. Learn how to lose cases. Winning cases is very important. Very easy to.
Well, I will only take one instruction from my singer. Next week.
Yes. All right. No, tomorrow.
Tomorrow.
Yeah. But I will not allow your senior to argue.
I will argue.
You get the point? I said try to learn how to lose cases. Losing is more important than winning. Let's this matter tomorrow as paid for.
Item 21, replacement.
And in this item number 21, the lordship may refer to the last date or order of the last date, my lord. There I was directed to produce the Anganwadi appeal file. Because there is a specific allegation.
That no notice of the appeal was ever served on his client in order to appeal it is necessary to produce the original file maintained by the appellate authority. Yes.
I had issued the letter to both both CDPO as well as ADM.
Hmm.
Now, my lord, CDPO personally came and she handed over the original file. But with respect to the Anganwadi appeal file, my lord, I have received a message, my lord, what they have shared it. ADM has already sent it to registry post that 122 pages of the original file.
Achha.
But on 30
Next week, next week, next week,
they have already sent it.
Then State Council is ready with the original file.
Appeal file.
No, original file maintained by the CDPO. However, the file maintained by the appellate authority is said to have been sent by the ADM by registered post, which he has not received as yet. Stop. Let's this matter next week.
Yes.
Item 42. So arising out of termination of Gr-Sok Sevak in the year 2014, the same appears to be
Disengagement order 4/10/2014 pass by the collector. Yes.
Short note for consideration.
Yes, pass it on.
One judgment of this on court in respect of similar situated employee of Gr-Sok terminated on same ground on same day has been decided and a matter was remanded to the collector for fresh application. The present petitioner.
Before presentation, my lord, may I say? Yesterday, my lord, one matter was also like this. It was disposed of, saying that, my lord, this disengagement order has been passed, my lord, after that consolidated
Comprehensive guidelines.
comprehensive guideline, my lord, that came into force.
No,
And there is a provision for.
When was it? When was it passed? When is the?
Next one. 4/10/14. Sorry.
2023 ରେ ଆସିଲା ନା 2018 ରେ ନା କେବେ ଆସିଲା ସେ comprehensive guideline ଟା ଦେଲା କେବେ କା ଡେଟ୍ ଟା ଦେଖ
ନା 17 ରେ ସେଟା 17 ରେ
no you will go to the disengagement order, that is the cause of action.
Yes ma'am.
ସେଟା ଆସିଛି 6/4/2018
18 ରେ
ସେ ହବନି
କାଲି
ଏଟା so will have to
ନା
consider.
ମୁଁ ଏଟା year of the case ରେ ଦେଖିକି ମୁଁ sorry.
The petitioner was joined in service on 7/1/2008. After continuance of service, however, on 29/11/2013, a show cause notice was issued against the petitioner at page 17, making allegation of a poor performance of the one. The Gr-Sok Sevak what required to create working days has not been created as per the market. In response to such so-called notice, petitioner submitted explanation at page 18, stating that since there is no approval project and sanction.
Anyway, he submitted his explanation. Then personal hearing was conducted.
Personal hearing was conducted on 24/12/2013, and the collector initially decided to disengage the petitioner on 31/12/2013, as is revealed from Annexure 1. And when the petitioner submitted application that will improve our performance, then the petitioner was allowed to continue in service. That means the termination order 31/12/2013, the punishment is likely modified, and I have allowed till 31st August 2014 to perform my duty. Thereafter, the impugned order under Annexure 1 4/10/2014 has been passed without any show cause notice or without giving any personal hearing within 30/12/2013 to 4/10/2014, saying that I have not improved my personal the performance. I have only raised 264 working days in 2014 and 15 financial year and 3,062 days in financial year 2013 and 14. This order was communicated by the PDDA referring the order of the collector DPC Ganjang, but which order has been passed by the collector has not been indicated in the impugned order. Only the quotation has been made by the order of the collector from DPC Ganjang, but there is no specification.
So this is the case, Mr. Patnaik.
Yes.
Once an order of disengagement was passed,
Yes.
but that was subsequently modified by way of conduct, not necessarily by an passing an official order.
Yes.
But it was never acted upon. He was allowed to continue.
Yes.
If he was disengaged, why was he allowed to continue? He should have been thrown out at that point of time. Then you allow him to continue, which means your initial order of disengagement is automatically nullified.
Yes,
Now subsequently, you again pull him up and disengage him without granting any opportunity.
That is the similar case.
That is
At page 8 of my note.
blowing hot and cold.
Page 8, my lord. Page 8 of my note, wherein the another GRS of same Ganjam district has been terminated by virtue of same order 4/10/2014. page 8 में जो आदि नोट टा देइछि 4/10/2014 रे टर्मिनेट हैला
आपन को ऑर्डर हो
आदि नोट
जा बुझा के तो बुझे नहीं
I am placing that order on page 8 of my note, the coordinate bench passed the order. The petitioner has filed this application seeking
ये अकर होनी है कौन इतना था कौन अकर
ସେଇଟାର ସେୟା କରିଛନ୍ତି
मुझे I have crystallized the point for you.
ଆଜ୍ଞା
Yes, Mr. Patnaik.
Well,
How can you justify this?
if your lordship will come to that impugned order that is 4/10/2014.
Yes.
There, my lord, admittedly, a decision was taken after the chance, giving a chance of personal hearing on 24/12/2013.
Where is the original order of disengagement, Mr.
That is
Satpathy?
31/12.
communicated. Since I haven't allowed, that has not been communicated.
My lord, lordship may peruse that is in
They
the
have also not filed in their counter.
para number 4, my lord.
Yes.
And whereas he was given sufficient scope to be sincere and improve his performance, he failed to do so. After careful examination on the merit of his case, he was disengaged by this office letter number 10021 dated 31/12/2013. But on his written prayer and promise for improvement of performance, the collector cum DPC postponed the disengagement order till 31/3/2014. My lord, this there is a catch in this particular date, my lord. Because the period of contract actually, my lord, that was continuing up to March 2014. So, my lord, when they decided to take a decision by disengaging him from service during the period of the contract, that was the decision at that particular point of time. But they wanted to extend that particular period till the completion of the contract.
That is the mistake.
Whereas,
that is mistake number 1.
Then, my lord, whereas he has helped generating only 3,062 percentage during 2013-14 and generated only it is therefore conclude. Therefore, 3 months subsequent error. Including all the performance satisfactory not like
satisfactory not like se nije decide kole na ताको explanation मांगी लगी
ना
ताको explanation मांगी लेनी अच्छा निजे decide कले जे ताको performance satisfactory नुए
the speaking order says so
कौन species
नहीं ये किसी कहूँ जे से कि they had asked for further any explanation
सरला the petitioner I am setting aside it I will set it aside but are you continuing still?
Center is vacant. Termination पर हम going to.
It will be reinstatement. It will be reinstatement without any back wages.
And in the meantime, one IA has been filed for enclosing a copy of the advertisement.
Fresh advertisement. Fill up करिए.
That is IA number 11693 of 2024.
So that writ application has to be heard along with this.
This second writ application, the advertisement was issued, selection was made, but nobody has joined in till that center is vacant.
No. If this court sets aside the original order of disengagement then and directs that he will be reinstated, the question of advertisement automatically goes. So we will have to also dispose of the other writ application. Other writ application our assignment. अच्छी था संग अच्छी
ना
चल तो कट लो बाबू
711 of 2018.
Yes. लिखिए दो. Both these writ applications being intrinsically connected on facts were heard together and are being disposed of by this common order. The petitioner was engaged as Gram Rozgar Sevak of Orakhpur Gram Panchayat under Purushottam block of Ganjam district on 7/1/2008. While working as such, a show cause notice, कहीं से show cause notice कहीं?
So cause notice page 17, madam.
A show cause notice. Not page 17, I think annexure 3. The show cause notice was issued to him by the project director DRDA on 29/11/2023. To explain his lack of performance. The petitioner submitted. ଆପଣ ଆପ୍ଲାଏ କରୁଛନ୍ତି କି? କାହା ପାଇଁ?
I am for OP6.
କି ସିଏ?
The
I am
second
the
petition,
successive candidate. As
In
per
favor of whom the
next
engagement order was issued.
Then he has to be heard. He also has to be heard. ଆପଣ କହୁନାହାନ୍ତି ସେ କଥା? ଆପଣ ବସୁଛନ୍ତି? ଆପଣ
एकटा नौचंदी बोली कहले तो
ଏକ ଦିଟାଙ୍କୁ ମିଶେଇକି ଡାକିଲେ ନା?
नहीं एकटा एटा गुड दिन आसो I have to take instruction. He stated that he has not been engaged. I have to take instruction.
How has not been? Stay ହେଇଛି ପରା?
नहीं
This order, this court has
Ita has
stayed.
been after selection, my lord, she has been engaged or not. I have to take instruction.
the rejection list of engagement, her name is found.
No. Anyway, but there is an order, interim order passed by this court in the connected writ application.
Lordship, keep it to
That
one
any
week
action
after
taken
I
in
have
the-
to take instruction.
No, it has said any action taken in the meantime shall be subject
Yes.
to. So let him. All right. Let him take.
That is page number 7 of the second writ, my lord, of 2018, annexure 1, where the offer of engagement order was issued.
Anyway, but he will be affected, so he has to be heard. Heard in part, let's this matter on. प्रथम तार खाली करिवे ना आटा तो उही थी केस matter on 27 September. Yeah. Item 22.
Item number 23.
23. अच्छा.
May I please, Lordship? My lord, in this writ application, the annexure 11, page 66 is under challenge, whereby the representation of the petitioner has been rejected. This is second round of litigation. The representation of filed by the petitioner has been rejected on erroneous grounds. Though as per my RT application, vacancies are there. Out of five candidates for which are reserved.
What are your facts, sir? Please first say the facts.
The facts of the case, my lord, the petitioner had applied for the post of Sikhya Sahayaka in the pursuant to the advertisement dated of the year 2016-17 in the year 2018 for Balesur district for Sikhya Sahayaka under the physically handicapped category OH for arts in arts category, Lordship. Thereafter, Lordship, her name was she was found eligible and her name was found placed on serial number 188. That is at page. Lordship, we can have a glance at annexure 6 page. This page number 49, Lordship. Serial number 188. She was found, her application was found to be eligible.
48.
49, Lordship. 49, serial number 188, your Lordship.
Yes.
Sasmita Rani Behera, she was found eligible, having the total aggregate was 161.666%.
Okay.
Thereafter, Lordship, to surprisingly, after being from a reserve category, handicap category, she was to be referred to the medical board for determination of her disability, Lordship. But she was not referred to the medical board. Out of 15 numbers of candidates, 11 were referred to the medical board, 9 were rejected, 9 of them were rejected, 2 were selected. And posts were 5, your Lordship, 5 in numbers. This petitioner was never referred to the medical board. The petitioner filed a writ application saying, praying for a direction to the state project director that I may be also referred to the medical board and my disability may be taken into consideration. I may be adjusted in the vacant post, your Lordship. But the representation has been rejected, and and against that, the petitioner has come up before your Lordship. Last occasion, the State Council was directed to file the counter.
Counter the file is.
Counter is there.
Before, my lord, but the order is of the State Project Director. She has not filed the counter.
क्या कहता तक भाई फाइल करते हैं so what was the order?
The order is at annexure 11, your lordship,
Page number 66.
page number 66. My lord.
On what ground? There is no vacancy.
There is no vacancy, but as per my RTA application, that is annexure 7, your lordship. Annexure 7, the relevant page being 54, your lordship. 54, serial number 2. It is for Valeshwar. It is the total number of vacancies 5. Then thereafter, lordship, page 55, your lordship. May see.
4 is vision impairment. 1 is HI.
Lordship. Lordship, may kindly have a glance at page 55, your lordship.
Yes.
8. That is Sanjay Kumar Raut, PH6 has been engaged.
PH6 no VI.
PHVA, sorry. PHVA has been engaged. Then Chandrakanti Jena, SC, PHOH, PHOH and PHVI, second round engaged. Only 2 have been engaged. The posts still remain vacant, your lordship. Thereafter, the government came up with a resolution that is annexure 9, your lordship.
Increasing it to 4%.
Yes, your lordship. Thereafter, lordship, may kindly have a glance at page 57, your lordship. Page 57, that is 4. Inter se exchange and carry forward. Reservation for each thereafter, reservation for each category of mentioned in subpara 1 shall be made separately, but in nature of vacancies in an establishment in such that a person with specific category cannot be employed, the vacancy may be interchanged among these categories. The head of the department shall be competent authority to allow exchange. If the post is identified for more than one category, preference should be given to the category which is less represented. If the vacancy reserved for any category of disability cannot be fulfilled due to unavailability of suitable person with a disability or for any other sufficient reason, such vacancy shall not be filled and shall be carried forward as a backlog to the subsequent recruitment year. There are lordship. 4, lordship. The vacancies reserved for person with disability shall be filled by the person with disability only, and de-reservation shall not be made in the case of direct recruitment. The reserved vacancy shall remain vacant till it is filled by the recruitment of the person with disability. Employer shall make sincere efforts even within the same recruitment year to fill up the reserved vacancies. Lordship, then lordship, may kindly have a glance at the notification, lordship, that is annexure 1, page 22, your lordship. The relevant be page 23. That is serial number 5. Select list shall be prepared and will valid for 100% of the vacancies of the district. I pray lordship, since 3 posts are remaining vacant, I being a candidate with physical disability, I have more than 50% disability. I have annexed the disability certificate. I only pray lordship, let them consider my name for the medical board. I may be. If I
No, one order has already been passed rejecting your claim. So that has to be first seen.
Gotcha.
Yes, Mr. Patnaik.
My lord, lordship may come to the guideline, but my learned friend actually annexed, my lord. That is annexure 1 and annexure 2. And more important is annexure 2. That's as with page note 24. And with respect to the PWD candidates, my lord, there is a condition. Yes, ma'am. It is at page number 30, my lord. 8.2. The PH candidate having temporary disability shall not be entertained for engagement. Person may come to page number 40.
14.
40, my lord. If this is the disability certificate that my friend is relying upon, and that being issued on 5/2/2018, then it is temporary in nature. And it is valid only up to 2023 for a period of 5 years. And second thing, my lord, in the rejection order, what we have stated, that the name of the petitioner, it was reflected in the list at serial number 188. That is not the merit list. On the contrary, that is the eligible list. Now, my lord, our specific stand is that, my lord, wherein it has been reported that the present petitioner, Srimati Sasmita Rani Behera, was not selected under any of the provisional merit list prepared for the first and second round, respectively. She was not figuring within that particular merit list, my lord. Now, what she is making a claim, my lord, that I may be permitted to go for appearing in the medical state of appellate medical board. But that occasion will arise whenever there will be a consideration of the case of the candidate to offer an appointment. Then in terms of that 2017 guideline, before offering any appointment in respect of any PWD candidate, the person has to be once again checked by the state appellate medical board. So the prayer in this case is to recommend her name for examination by the appellate medical board. But unless and until there will be an occasion to offer any appointment to her, the recommendation of the name of the petitioner to state appellate medical board, that does not arise. And second thing, with respect to the vacancies, that also, in the same rejection order, it has been stated, saying that that is in para number 5, that further with reference to the claim of the petition to refer on name as against the PHOH post, the DPC Baleswar has intimated that the clear vacancy position of PWD candidate under +3 arts category was downloaded from SS Recruitment 2016 link of OPEBA website on 12/1/2018, through district login, but the date was mentioned in the form of MMDDYYY format, that is 1/12/2018. That means it is 12/1/2018. which was prepared by NIC Bhubaneswar, and the same was kept in file. Inadvertently, the same report was given to the RTI applicant, that is the petitioner, on 7/3/2019. Later on, it is found that the same report was withdrawn from the district login after increase of the PH vacancy from 3% to 4%, for which at present there is no vacancy under the PHOH category in +3 arts category for SS recruitment year 2016.
No. As you have pointed out, first I would like you to satisfy the court that you were selected, or you came within the zone of selection. Even assuming that you can be considered eligible, even though you have a temporary disability, you must first satisfy the court that you came within the zone of consideration.
Page 30, Your Lordship, what my learned senior had pointed out in the notification, page 30, 8.2, Lordship. Physical handicapped candidate having temporary disability shall not be entertained for engagement. The candidates, those who avail the reservation relaxation of age limit under the provision contained in these rules under PH category shall have to appear before the state medical board before their engagement. Lordship, in this case, I have not been referred to the medical board. Assuming I have a 50% disability, I should have been referred, but they did not refer me. They straight away.
Because you have a temporary disability, and temporary disability is not to be considered. That is the case.
My lord, the line also, that particular sentence is also clear to that extent.
Very clear. The PH candidate having
engagement, my lord,
having temporary disability shall not be entertained for engagement.
No, so
sending you to a medical appellate board would have been written at.
What they have filed the opposite party number 4 has filed the counter. Lordship, kindly see in the counter what they have stated. Counter, that is page number 2, internal page of the counter, paragraph 5, Your Lordship. Paragraph 5, Your Lordship.
Yes.
That it is humbly summed that the petitioner was not found placed in the provisional merit list prepared in the first and second preference. The petitioner secured 161.666% in total. The candidates, namely Antarjami Padi, General OH, Bhaskar Chandra Bala, Chandrakanti Jena, Sasmita Rani Behera, SCBC OH, and Sunanda Mani Raj, were found placed in the eligible list of PHOH category. Sri Antarjami Padi did not qualify the appellate medical board. Sri Bhaskar Chandra Bala did not appear the board. Chandrakanti Jena was elected PH VI category. The case of the petitioner named Sasmita Rani Behera, SCBC OH, 161.66% and Sunanda Moniraj were not referred to the medical board as their name did not find place in the first and second round selection. It list prepared under the said category of Baleswar district, Lordship. Lordship, my only contention is that since there are vacancies, I may be.
The last person to have been appointed among these group is, I think, Bhaskar Chandra Gowda, 166.42%. That may have been the cutoff mark also in that category.
This one. I do not have any specific information to make it submission.
What I pray, Lordship.
Yes.
Short date may be given. I will file a rejoinder with a note. Thereafter, Lordship may kindly.
All right, Learned Counsel for the petitioner wants to file rejoinder to the counter filed by the opposite party number 4. Place this matter on 30th October. Rejoinder, if any, be filed in the meantime.
Item 24.
In this case, the petitioner initially was employed as Anganwadi worker. After completion of 30 years of service, the petitioner, yes.
My lord, this is a matter relating to the gratuity. And in the meantime, my lord, because I have received a para-wise from the CDPO. But here, a policy decision is to be taken with respect to entitlement of the gratuity in respect of a person who is receiving honorarium. So I have already intimated to the government, and on Friday, my lord, actually, I'm going to have that PWC. So also, my lord, by the next week, my lord, I will file the counter.
State Council.
Government is to file the counter, my lord, in this case.
State Council submits that he would file counter by next week and requests for adjournment. Is this matter
30th October.
on 30th October?
Item 25.
I have issued the counter, my lord. Next week, any date.
Learned Counsel for the petitioner has received the copy of the counter and wants some time to go through the same. Is this matter
27 September, sir.
on 27 September?
Item 26.
26, yes. I pray one more time, Lordship, to file amendment. It come next week because she has to come and file that.
Is this matter next week as paid for?
Item 27 September.
27 September.
Yes,
This matter on 27 September.
Item 27.
behalf of Mr. T.K. Mahathi, I pray 1 week after he has gone to out of state for treatment of his father.
Is this matter
23rd October.
on 23rd October as paid for by the
Item 20.
counsel for the petitioner?
Give it one more time, my lord.
I think my lord didn't mention, my lord. In item number 27, there is an entry mortem question. So it is to
Entry model to continue 27 record 28 record to is this matter
30th October.
on 30th October as paid for.
Item number 30.
29
The next week.
Oh, next week is item 30.
My lords, I'm appearing virtually. I'm appearing on behalf of the opposite party, my lords.
No one for the petitioner, let it be passed over. Sabri will dispose. Yes.
Item 31.
May I please your lordship? I am from the opposite party.
Pass over.
Item 32.
May I the lordship? My lord, this is the transfer petition. My prayer is to transfer my case pending in the court of Annexure 1, pending in the court of
No, see, no. The notice was served on the father of the opposite party. No
My
counsel.
lord, notice was served. But the father of the opposite party received the notice. Notice that the Bappa received, but the opposite party did not prefer to appear in this case. My only humble prayer is there are 3 proceedings pending in the Bhubaneswar, and the petitioner is lady is a research scholar. So she is staying at Bhubaneswar. So it is very difficult on her part to attend the civil proceeding filed under section 9 at Baleswar. Transfer he just 3 proceeding Bhubaneswar.
ट्रांसफर होबो ना होबो से तो अलग कथा কিন্তু নোটিশটা আগে জারি ন হই পারলে
ଯାଇଛି ତାଙ୍କ ପାଖକୁ ଯାଇଛି ତା ବାପା ତା ପାଇଁ ସେ ଜାଣି ଜାଣିକି ମାନେ intentionally ହି ଯାହା
that you may say that, but how can the court give a finding that she intentionally avoid করছেন? এটি as against so local situation.
interim prayer ଅଛି ତାହେଲେ
You do one thing, you serve another copy on the state council, will get it served through the police. Let an extra copy of the transfer application be served upon the state council, who shall ensure service of the same on the opposite party through the IIC of the jurisdictional police station, indicating that the matter shall be taken up for hearing on
9th October.
on 9th October. Interim order achi?
ନାହିଁ interim order ନାହିଁ previously this honorable court
You have filed any IA? You have not filed any IA?
ନା no maila
All right, so it will come on 9th October, we'll see. ନାଇଁ IA ନାହିଁ.
ଆଏ ନାହିଁ କଣ କି ସେଠି ଭୁବନେଶ୍ୱରରେ କେସ୍ ଚାଲୁଛି କିନ୍ତୁ ସେଠି ଆକୁ ଯିବାକୁ ପଡୁଛି ସେଠିକି
କଣ କରିବା?
ମାନେ
ଆପଣ IA ଟେ ଫାଇଲ କରେନି, ଷ୍ଟେ କରିଦେଇଥା। ଫାଇଲ କରେନି ମୁଁ କଣ କରିବି? 9th October.
ସେଦିନ ନ ଆସେ ମୁଁ ଆଏଟା ଫାଇଲ କରିଦେବି
ତା ଭିତରେ କରିଦେବ।
Item 33.
Final mediation report. କଣ ହେଇଛି ଏଥିରେ?
Petitioner is set up this TRPC
This mediation has been successful.
unsuccessful.
Unsuccessful.
The husband has
As per the report, as per the report submitted by the mediator, the mediation between the parties has ended in failure. The transfer application is therefore taken up for hearing. Transfer application, you are the petitioner by the wife. You want it to be transferred from Kotak to Nabarangpur.
My lord.
Yes, what do you say?
My lord, the present address of the present petitioner is Dhenkanal, your lordship. As he is working.
Yeah, Mr. Mahathi.
As he is working in Nabarangpur, so the petitioner wants to transfer from this Kotak to Nabarangpur. So my lord, my present address is Kotak, your lordship. So
Virtual?
my as my
Virtual.
lordship, please.
Transfer application allow कर दो, virtual हमारे husband को जो virtual था कर दो, ना? नंबर क्या हुए?
The husband has given undertaken to pay the
Yes, एथिरे मो
yeah. In mediation he has given undertaken to pay the fee. Your honor has directed to
No,
pay
no,
the
this court has no jurisdiction excepting directing the proceeding to be transferred from one place to another.
your
Yes.
lordship has directed.
What directed?
In order dated 1/7/24 your lordship directed to pay the fee to come to mediation. But he has paid only 2 times and he has given undertaken in mediation center to pay the rest fee, but he has not paid. As per lordship.
ये छाड़ो.
Item 34.
May I plead your lordship? On the last occasion, my lords had directed to furnish the status of the pending disputes at Bhubaneswar. We have filed a memo for the same yesterday only.
Okay. You got notice जाए नहीं? There is no appearance in order to grant one more opportunity. How many cases are there?
Your lordship, 3 cases are there.
At Bhubaneswar?
Yes, your
You
lordship.
wanted to be transferred from
SDGM Raulkela to SDGM Bhubaneswar. She had filed a DV case at SDGM Raulkela.
Yes. What is your good name?
My lordship, Arpita Mahapatra.
Yes.
Arpita Mahapatra.
Miss Arpita Mahapatra is present for the petitioner. None appears for the opposite party, despite repeated calls. On the last occasion also there was no appearance from the side of the opposite party. Ms. Mahapatra files a memo mentioning the details of all the cases pending before different courts at Bhubaneswar between the parties. The same be kept on record. Oh, sorry. Transfer application allowed. Yeah.
Gratefully, lordship.
35.
Multiple cases are pending at Bhubaneswar. It will be more convenient to the court. Item 35, yes.
On last occasion, Lordship was directed to file requisite through court process. But before uploading of that order, we have filed requisite.
Alright. The requisites filed be accepted and notice be issued as directed, fixing a short returnable date. Is this matter on 30th October?
Lordship, there was an interim order.
Interim order to continue.
Obliged.
Item 36. There is a noting that instead of filing requisite.
Same order.
issue
Same order. Proceed.
Through speed post, I
After
filed
that,
register post.
Same order. Same order.
Yes, my interim order to continue. Item 37. Interim order to continue.
Interim order to continue.
Even my petition but copy not solved.
Key modification by file good state.
State has filed.
State file good sorry.
Dates my order not complete, not release my salary. And now they file a petition about videos.
Kete आइए कौन पे?
Sir, IA number 11983 of 2014.
कौन modification?
So, sir,
The DO was present in
my lord, the Lordship may come to the prayer, my lord.
No, what is the?
Lordship may come to the prayer in the IA. There, a prayer has been made to pass appropriate order to modify, clarify the judgment dated 8/8/2024 passed in WPC number 7918 of 2018, particularly with regard to the observation made in para number 11 of the judgment.
What is the para 11? Let us see.
Para number 11 is the submission.
Yeah. Submission में कौन कर? हैं? एक लाख रिजेक्ट कर दो? हैं? चेक राउंड सार दो आपको? Where is that judgment?
Page note 21 of the petition.
ये judgment है कहीं?
I mean, this is page note 21. ଆମର ସେ petition IRA ଲାଗିଛି. Para number 11.
Yeah, what modification actually you want?
So para number 11 ର clarification କୁ ସେ ଚାହୁଁଛନ୍ତି ଯୋଉଟା କି
It is only the submission of Mr. Mahanti.
yes, as regard the order.
I have said that instead of conducting an inquiry or verifying the records, which would have proved the misconduct of Jyotsna Mahanti, the director straightaway set aside the order of suspension to carry on. So this is the submission made by Mr. Mahanti. That I have written.
Yes, sir. Not
Okay, sir, এটা 8/8/24 ପରା.
So what modification do you want?
ସେ 10/4/24.
You go through what is the you give a copy of the IA?
My lord, I will do that.
Let a copy of IA 11983 of 2024. Let a copy of the IA be served upon Sri Mahanti appearing for the learned counsel appearing for the petitioner. Is this matter? On 23rd October. Yes, Mr. Patnaik, on 23rd October.
My submission till that not release salary. The DO present actually my lord to release
ସେଥିରେ କ'ଣ ଏଇଥିରେ ପାସ୍ କରିବ?
ମୁଁ ମିଷ୍ଟେକ୍ ରେଡି କରିଛି ଭାଇ କରିବା
ଆପଣ ମିସକେସ୍ ନାହିଁ କଣ୍ଟ୍ରାକ୍ଟ ଫାଇଲ୍ କରିବ ନା ମିସକେସ୍ ଫାଇଲ୍ କରିବ?
କଣ୍ଟେଣ୍ଟ ଅବସ୍ଥା ଖରାପ।
ଆଉ କ'ଣ କରିବା? Yes. Item 38.
ମାନେ ଆଟେ ସର୍ଟ ଡେଟ୍ କରିବାକୁ
Short date କରିଦଉ।
ସେଇଆ କରୁନ ଅର୍ଡର ଆସିବ ତ?
9th October.
ଆଜ୍ଞା ମାଇ ଲର୍ଡ ବିବର ରାକେଶ
38.
Item 38, my lord, order dated 9/4/2024. The lordship was pleased to pass the bail order.
9/4/2024.
My lord, I am seeking modification to the extent that my lord had placed a condition of rupees 10 lakh as cash security. Lordship, with this
Similar matter ଆସିଥିଲା ବୋଧେ?
My lord, ଆସିଥିଲା 1 week.
Amount ଅଲଗା ଥିଲା, ଏ lordship fixed.
It was 26 lakhs and odd ଥିଲା.
Or ଥିଲା 10 lakhs ଏ
My lord,
lordship.
I had asked you to take instruction.
my lord,
Yes.
taken instruction. Two things. At 10 lakh, I humbly pray for he can pay 2 lakh, or else he can pay 10 lakh as property security.
Property security ହେଲେ ବହୁତ ଅଧିକା ହବ।
At least 4 lakh capacity ତାର ଜମାରୁ ନାହିଁ. Otherwise 9/4/2000.
I'll make it 5 lakhs.
Lordship proposed on the last occasion. 5 lakhs.
5 lakhs I will that is why Mr. Naik I had asked you to take instruction.
My lord,
ଆପଣ ବି ଜାଣିଛନ୍ତି 5 lakhs ଆଣିଛନ୍ତି କିନ୍ତୁ କହିଲା ବେଳକୁ କହୁଛନ୍ତି କୋର୍ଟ 2 ତାପରେ 4
my lord, no, ani.
ତାପରେ 4.5 ତାପରେ 4,75,000.
My lord, I am standing in the court. I'll not lie. He told me to.
No, you don't have to lie or
5 lakh.
you have to represent your client.
My lord, he has actually asked for 2 lakh. I'm just submitting. My lord will pass any order. Bahari Parini 9/4.
This is an application for modification of modification of order dated 9/4/2024 only to the extent of waiving the condition to deposit to furnish cash security of rupees 10 lakhs in the shape of short-term fixed deposit. Stop. Learned counsel for the petitioner submits that because of financial stringency, the petitioner has not been able to arrange the amount so far, due to which he is still languishing in jail custody despite being granted bail. Stop. He therefore submits that the direction to furnish cash security be waived and substituted by property security. Parallel State Council has opposed the prayer for modification by submitting that the petitioner is involved in serious financial fraud to the extent of rupees 26,60470, and therefore no leniency should be shown to him. After considering the submissions noted above, this court is of the view that the petitioner, despite being granted bail way back on 9/4/2024, has not been released because of his inability to meet the conditions imposed. Stop. It is well settled that in such cases, it would amount to refusal of bail altogether, thereby defeating the very purpose and intent of the original order, granting him bail. Taking into consideration the above facts, and particularly the fact that more than 5 months have elapsed, nearly 5 months, not 5 months ago, more than 5 months have elapsed in the meantime, and the petitioner has continued to be in jail custody despite being granted bail by this court, I am inclined to take a lenient view. The prayer for modification is allowed. Stop. It is directed that condition number 1 under paragraph 8 of order dated 9/4/2024 is modified only to the extent of directing the petitioner to furnish cash security of rupees 2 lakhs with all other 2 lakhs in the shape of short-term fixed deposit in any nationalized bank being pledged to the code below. Further, the petitioner shall furnish cash security, property security of rupees 10 lakhs to the satisfaction of the code below. Stop. All other conditions shall remain intact.
Grateful, my lord. Grateful.
Item 39. Correction of para 3 of the order, my lord. The court name. Inventory mentioned JMFC board bill instead of Chandikhol.
JMFC Chandikhol.
Chandikhol.
The word board bill.
Considering
the submissions also, the word board bill occurring in paragraph 3 be corrected as Chandikhol. Yes.
Another is, my lord, the offense, commission of offense only mentioned 394. For the commission of offense is 420. 419, 420, 423, 465, 468, 434 IPC.
The election further, the description of the offenses, description of the offense as section 394 of IPC be corrected as so and so, section so and so, so and so, so and so.
Extension of time.
2 weeks for the time is allowed to surrender.
Item 40.
Maybe. Lordship has a please to dismiss the case for non-prosecution on 17/10/23.
So you will have to file a CM appeal.
The IM may be converted. Otherwise, I'll again file another Bhakalatnama.
IE can it be converted? I don't know. Can it be converted? Interlocutory application? No. I don't think it can be converted. You have to file. Let's this matter next week. In the meantime, you would file.
Item 41.
41 same.
CM will be filed.
42.
Yesterday, my lord, the matter was listed that custody since 31.
Why was it adjourned to today?
Today that Ajit Behera, he is not being charge sheeted witness.
So he wanted to go through the charge sheet.
Yes, he repeatedly submitted that after despite several summons, he is not attending the court. So that's why I have taken instruction, but he has again said that not just.
So? No, what is the matter then? Papini Godu, I would reject it.
Yes, bail was refused. Directed move after examination of some witnesses. In the meantime, 6 witnesses has already been examined. They have not supported. There is no eyewitness to the occurrence, my lord.
Who are the main witnesses?
That they have relied last seen Ajit Behera. He is not been charge sheeted.
And another witness, my lord, that Ajit Kumar Mishra, before whom he has made a oral dying relation in telephone, my lord. Before the occurrence, he has stated that mate mane jogi janti, mate mari debe.
That will be relevant. Has he been examined?
No,
No, he has
not
not been examined. There was a previous enmity regarding the Panchayat election, due to Panchayat election, and they have threatened him.
The weapon was seized at your instance.
Yes, apart from that,
But
leading to
no such
discovery
liberty
that
was
was
granted.
seized from
No
the-
such liberty was granted, Mr. Sahu. It says, I am not inclined to release the petitioner Papini Godu on bail. Accordingly, the prayer for bail stands rejected.
Sorry. That is the fact, my
Already ମୁଁ ଗ୍ରହଣ
lord.
କଲିନି ଆଉ।
Who accused granted bail. Only that on the instance of the petitioner, weapon of offense has been seized.
Who are the ଖାଲି ଅଜିତ ମିଶ୍ର ରେ?
Ajit Mishra also not there. He is at Dubai, my lord.
ଆପଣ କି ଜାଣିଲେ?
I have taken instruction, my lord, from local council. He is at Dubai, my lord.
Local council କି ଜାଣିଲେ?
ସେ ଗାଁର ଲୋକଟା ପ୍ରାୟ। Let them take instruction, my lord.
So କଣ ହେଇଛି ନା, had that liberty been granted, I could have considered because the order was passed by Justice S.K. Sahu.
Yes, my lord.
He has passed a reasoned order rejecting your application. So now for me to consider it, it has been assigned to this bench by the Chief Justice. That is not an
Yes.
issue. So there must be something, some handle
Let
must be
them-
there.
Yes, my lord. Let them take instruction so far Ajit
Alright.
Mishra is concerned.
Sri Sahu submits that the earlier application of the bail of the earlier application for bail filed by the petitioner was rejected on merits. But in the meantime, several witnesses have been examined. And all of them, and none of them has supported the case of prosecution. He further submits that the only witness on whose evidence the prosecution relies upon is one Ajit Kumar Mishra. But he is unable to be examined as he is presently out of the country.
Yes.
Then State Council shall take instructions in this regard and apprise the court accordingly. Let's this matter. Puja Purva. 9th October. 9th October. You keep this. 9th October.
9th last day ସେଦିନ
9th is the last day.
ଆଜ୍ଞା ଏ ନେକ୍ସଟ ୱିକ ରେ ଆସୁ ଖାଲି ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ନେଇଯିବ କଣ
Next week.
ନେକ୍ସଟ ୱିକ ରେ
ଆଜି ହେଲା କେତେ?
ଆଜି ହେଲା 18 25 ରେ କି 26 ରେ ଆସୁ
27 all on 27th.
ଓ ପ୍ଲେଜ
चलो नहीं, you take it back.
Item 43.
नहीं सेतिक था.
May have taken loss. The petition in custody since 22/8/2023 with the allegation of transportation of 44 kg of ganja. Fellowship 4 persons were involved in crime.
West Bengal.
Is the man of West Bengal. And another the outsider also will consider.
I have granted. 3. কিন্তু ওটা ভুল করে দিয়েছি বোধহয়।
He also cooperate to the trials and that I also take instruction from the council.
Let what are the
trial court.
in this case? 2 vehicles were.
This is Rahul Mishra. Was he from? Was he an outsider? Is he an outsider?
Man of
Outsider but different
Man of
footing,
the-
madam.
Different?
He was different footing. He was not present at the vehicle where the ganja was seized, madam. His present petitioner and one
How one week up.
Malik. They were present at the desired vehicle in which ganja was kept.
Two persons.
They were escorting in the Alto car, that Rahul Mishra and one Bichitra Behra. They were escorting this vehicle in which the ganja was kept. That's why he has been granted, not seized from his possession. But present petitioner, from the desired car, it has been seized.
Except the present petitioner,
and
also
he is
other of 3
in the
persons were
consequence.
granted bail. But the another co-accused also the outsider, he also cooperated to the trial lordship, and they also appear in the before the law on each and every date of adjournment.
Not similar, though outsider but not similar.
In the vehicle lordship where the ganja was found, there are 2 persons were.
If you want, I can release this from my bench. No, not an issue. In many cases, I am releasing it. If I will not grant you with the relief, doesn't mean that I will stop you from getting the relief from any other place. You are free to. I will not grant you. I will not change my position, excepting maybe in some cases like Andhra Pradesh. They have a tendency to appear. Once, even if you release them on interim bail, they will definitely appear. But these cases, no. West Bengal, absolutely not. West Bengal, Bihar, Jharkhand, and all other cases, they will go away and they will stall the trial. This matter 1 week after.
Any terms and conditions?
No, no.
Any terms and conditions?
No.
Blood relation security,
No, no.
cash security.
No, no. As directed, learned court below has submitted a report that out of 5 prosecution witnesses, 3 have already been examined, and the matter is posted for
Since last
examination of the informant and the investigating officer.
Since last 2 months, they have not been examined. I'm giving 2 judgments to lordship.
No, I will not. I will not grant.
Lordship may kindly come.
No, no. I will not grant. The petitioner.
30 kilo,
No, no.
30 kilo.
No, no. He is an outsider. I will not grant.
And no criminal antecedents.
Sir, one order for everybody. There cannot be any distinction.
Judgments to lordship may kindly.
No, no, I will not consider those. You may, if you want to cite, you cite. You may argue, you argue, but I will not. I will pass a judgment. I will justify why I am not granting bail, but I will not grant bail.
I'm filing your lordship may kindly come.
Yes. The petitioner is in custody since
28/8/2023.
22/8/2023. 23. 28/8/2023 in connection with such and such case. The prosecution case is that the petitioner and another person were transporting contraband ganja weighing 30 kgs when they were apprehended by the excise officials. Sri Agarwal, running counsel with the petitioner, submits that the petitioner has been found prejudiced because of slow progress of trial, and therefore he may be released on bail. He cites two judgments of the Supreme Court rendered in the case of Muhammad Muslim alias Hussain versus State of Delhi also, and Sheikh Javed Iqbal alias Ashfaq Ansari in support of his contentions. Learned State Council has opposed the prayer for bail by submitting that there is clear evidence of the petitioner being present at the spot and of possessing and of being in conscious possession of the contraband. After considering the submissions and on going through the materials on record, including the judgments cited by the counsel for the petitioner, this court is not inclined to allow the prayer for bail, mainly on the ground that the trial is at the fag end, with only the investigating officer and the informant left to be examined. So, the bail application is therefore rejected. The court below is directed to conclude the trial as early as possible, preferably within a period of 3 months. Yes.
Item 45. May I please, Your Worship?
Yes.
This is third round of bail application by the petitioner, my lord.
Yes.
My lord, in the first bail application, Your Lordship had directed the trial court to complete the trial within a period of 6 months, my lord. It was not completed.
No, 8 months.
8 months, my lord.
Yes.
Anyway, my lord, the subsequent bail application was my lord, disposed of with a direction to dispose of the bail application within a dispose of the trial within a period of 3 months, my lord. Till date, the trial has not started. And of course, my lord, ganja quantity is 76 kgs, my lord. And Your Lordship has rejected the bail application solely on the ground that he is an outsider, my lord. In fact, my lord, my instruction is this man belongs to Odisha, my lord. His permanent residence is in the district, my lord, in Malkangiri. His father, mother stays there, my lord. And this man, he is doing job in Chhattisgarh. Therefore, his Aadhaar card and other things, those have been prepared there, my lord. And for that reason, his address has been shown as Chhattisgarh. In fact, his father, mother, they stay in Odisha. And 3.5 years, more than 3.5 years, he is in custody, my lord. And his mother is seriously ill, and she is.
The court below is directed to submit a report on the status of the trial. So, further, the State Council shall also take instructions with regard to the submission that the petitioner.
This address given in the first title, whether
ना सेटा किंतु बापा तार एफिडेविट गोटे करिसेंती जोथिरे से लिखिसेंती ही बिलोंग्स टू गुराखुंटा पोस्ट डिस्ट्रिक्ट मालकानगिरी
is a permanent resident of the district of Malkangiri, though for the purposes of employment his Aadhaar card and other documents show him to be a resident of the state of Chhattisgarh. List this matter
7th October.
on 7th October. Yes.
The trial has been delayed due to non-surrendering of co-accused. The NBW issued.
Let him
नहीं नहीं सेटा आमे से co-accused कौन कला के मु सफर करी सकते तापे स्प्लिट अप करी मोर करी परिबे because
yes.
Item 46.
This is the third bail application for presentation of
and the presentation inside custody since 21/5/2021, my lord. In last occasion in BLP number 5681 of 23, you will also please to direct to expedite trial within 8 months. If it will not conclude, the liberty was given to the prisoner to renew his prayer, my lord. In that bail application, I have also filed one IA in which you will also observe that he is tested as hepatitis B positive, my lord. But the jailer submitted the report that he was condition was stable. That's why he was not inclined to grant him interim bail. And he will also dispose of with that observation that if 8 month trial has not been concluded.
Court below is directed to submit a report as regards status of the trial. List this matter. On 7th October. On 7th October.
Recently, I have annexed that.
27/7/2024. Out of 23 charges witness, one witness has been examined. I have annexed that.
देखिए
Item 47.
Chairman, FIR lost against 30 to 40%. The background of the case is that Mathili police, they got information that in the nearby jungle, a group of persons, villagers, nearby tribals, they have been carrying some ganja. They went to the spot. On seeing the police, most of them ran away. They detected this 8%. Out of 8%, 6% are before your lordship. They detained, but subsequently villagers came and took them away. So they seized about 138.950 quantity of ganja.
I have granted you interim bail for 3 months.
Yes, thereafter your lordship had directed, and before completion they have surrendered. They are inside jail, my lord. In the meantime, out of the same case, my lord, another case was registered in the Machkund police station because they went to the village. Police then went to the village. There was a tussle between the villagers and so and so, and therefore 395 all this. But this honorable court has been pleased to grant bail in the connected case, my lord. Annex 3, I have annexed the document. Now these people, my lord, they say in the FIR, they say that they could not follow the procedure as required under section 43 seizure and arrest. They say because these people are not there, so they found this matter on the spot, so they could not seize. This is the background of the case, and charge sheet was submitted against these petitioners along with 30-40 others. This is it.
No.
And one more, in the meantime, trial has commenced, and 2 witnesses named in the FIR, independent witness, those who are present at the time of seizure, they have been examined. I have also filed the copy of the deposition. They say nothing. Under Annex 6, they say nothing. They are present. They have not been seized. This is the only.
No, I will not grant that.
Your lordship.
This is
And trial, since trial has begun, 32 charge sheet witnesses are there.
This is a successive bail application filed by the petitioner seeking his release on bail. Stop. He is in custody since 16/5/2022 in connection with such and such case. His regular bail application for bail was not considered or not favorably considered by this court. Looking at the prima facie materials showing his complicity in the alleged occurrence. However, he was granted interim bail for a period of 3 months. Looking at the period of detention. Stop. In the meantime, trial has commenced with 2 witnesses being already examined. Stop. Since trial has commenced, I do not find any reason to release the petitioner on bail, particularly when this court was earlier not inclined to grant him bail on merits of the case. The bail application is therefore rejected. Yes.
Finding expedite trial.
The trial court is directed to expedite the trial. Yes.
Item 48.
May I plead your lordship?
Yes.
Fourth bail application of the petitioner and offense under section 20B2C and DPS Act matter. 128 kg ganja seized from the 3 persons. 1 person suspect from the spot, 2 persons apprehended. My lord, now at this stage, my lord, the trial is still pending. My lord. Out of 18 witnesses, 5 witnesses have been examined.
I've already granted you interim bail for 3 months. The only relief that could have been granted by me by stretching the law a little bit, I've already granted you.
They also extended. What I remember.
Trial manual not
No. କିଛି ହବନି
21 custody manual 10 21
128 kg ଗଞ୍ଜେଇ ଆଉ
seizure from the 3%.
କଣ କରିବା କଣ କରିବି
Meantime, my lord, 14 ତା mother ଟା expire କରି ଯାଇଛି
ଆଇଏ ଫାଇଲ କରନ୍ତୁ ଦେଖିବା ଫାଇଲ ନାହିଁ 14/9 ଫାଇଲ ନାହିଁ it can be taken up tomorrow
3 months my lord interview
କାହିଁକି 3 months କାହିଁକି ଆଇଏ ଫାଇଲ କରନ୍ତୁ ଦେଖିବା but 3 months
ଆଇବନି ପାଖ ହବ ସୋମବାର ତାର ଅଛି ବାର
ଏ
ସୋମବାର ଅଛି ବାର
14/9 ହେଲେ କେତେ ହେଲା
10 ଅଛି
10 ମାନେ 23/9 ଖଣ୍ଡ ହବ 10 କାଲି ଫାଇଲ କରନ୍ତୁ it will be taken up tomorrow list this matter tomorrow as paid for
There will be copy so that I can take instruction.
yes
Item 49.
as you have telephonic instruction yes
Yes, madam. That's why.
yes item 49
49.
Hello.
May it please your lordships. I'm on VC your lordships. I'm on VC.
अच्छा तो कौन आते हैं विषय रचना कौन
My lords. The petition is in custody from 18/7/2021. And the alleged quantity is 166 kgs. Your lordship was pleased to release him on interim bail and he has duly surrendered after that. The trial has not concluded, your lordships, in the meanwhile.
all right
May I please status reports?
the court below is directed to submit a report with regard to status of the trial list this matter on 7th October
Lordships.
Item number 50.
51 पर कहीं जाए 50 तो 50 रहे 50 से अधिक कहीं जाए yes छड़ा 51 51 टा नहीं देखिए सर ये आउट देखिए 51 not press all right not press
Item 52.
That's may I be permitted on behalf of Mr. Barik. Well, it's offenses under section 457 and 380 IPC. As co-accused on similar footing has been released on bail by this honorable court.
yes
madam.
same order
Yes.
So item number 10.
none appears list this matter after vacation
So item number 30.
Tiris go Tiris
Appearing from the opposite party, my lords.
if none appears disposed of
So item number 31.
My lords, I have a small prayer to make, my lords. In item 30, the noting says that Mr. Debashish Panda has appeared entered appearance on behalf of the petitioner, my lords, but we have entered appearance for the opposite party, my lords.
इसलिए कहीं पसिया इतने पुल लिखा है कि without taking consent from the previous counsel why should we get into that altogether I am dismissing the case of the petitioner what have you got to say dismissed है ना हाँ फिर जो हम रहेगी dismissed
Item 31.
31
May I please your lordship?
yes
I'm for the opposite party, my lord.
none appears disposed of
So item number 50.
item 50 none appears next week or none appears tomorrow yes yes then
Yes, sir.
sorry अच्छा पाठटा आगे नहीं की जब सर होगा नहीं ओह
Duty list item number 3.
ମୁଁ ଖାତାଟା ଗୁଲି ପକେଇଛି ମୁଁ କାଗଜ ଗୁଲି ପକେଇଛି ମୁଁ କାଗଜ ଲେଖା ଗୁଡା
Lordship, last time I had placed order 41, rule 30.
order 41
Rule 30, judgment. And
Limited demands, 3,000 was noticed, but I mean not disclosed.
Only two words I will. Rule 30.
Yes.
The last two lines shall pronounce judgment open court. In the instant case, it was vacation, so there was no open court. Only two words. Either at once or some future day which notice shall be given to the parties or their leaders. Here the notice has not been given. The word shall is mandatory. So mandatory, a duty is cast on the court to give notice to either to the parties and pleaders in the instant case, not issue. Then, Your Lordship, I'm coming to the substantial question of how that remand order. That is one. Lordship may turn to order 41, rule 23.
Remand.
Remand substantial question of law 1. Order 41, rule 23. Order 21, rule 23, it stipulates the suit ought to have been disposed of on a preliminary issue. In the instant case, the suit was, all issues were answered. So it is not applicable. Then, Your Lordship, by amendment, order 21.
No, I mean, why are we discussing this? Order 41, rule 33, 23?
Because it is substantial question of law. What was the substance?
What happened? Was it remanded?
It was remanded. Suit was dismissed. We went in appeal. In appeal, it was remanded
to the trial court.
To the trial court to frame issue on Benami and answer.
So it was a limited. Oh, you are arguing that it was a limited remand.
My case is it was a limited.
So order 41, rule 23
is if the suit is disposed upon a preliminary.
No, but why are you referring to order 41, rule 23?
Because it is substantial question of law which was.
No, why is it relevant?
It is relevant because the trial court and the appellate court, they say it is open remand.
Yes.
My case is it is a limited remand. And this has been raised in the first appellate court.
Yes.
And in a cryptic manner, in two sentences says that it is a open remand.
Okay.
That is why the first substantial question of law is this. Then 23A. 23A says, when there is a retrial, in the instant case, there is no retrial.
And a retrial is considered necessary by the first appellate.
It is not a retrial.
Yes.
Because only 3 witnesses were examined and the issue is one. So it is not a retrial as a whole.
Yes.
Then Your Lordship may come to rule 25.
Yes.
Where appellate court may frame issues and refer them to trial whose course decrees appeal for. So my case, it comes under rule 25. That is the substantial question of law, my lords. That was framed. I am reading the substantial question of law. One was whether the learned trial court has exceeded in the direction of the first appellate court in the earlier appeal RFA to reopen all fresh issues. This is the first. So my case is that I have distinguished 23, 23A and 25. So it falls within 25. The next substantial question of law, whether finding on Stridhan properties of the plaintiff by the learned trial is the alien to the pleading and issues between the parties. My lords, if Your Lordship goes to paragraph 3, it says it is the royalty lands of Satyavati, my mother, the plaintiff says. There is neither evidence nor pleadings that it was the Stridhan properties of the Satyavati. Our case is that it was purchased in the name of Satyavati by our husband and my father's, because the government, he was a government servant. The government did not give permission to purchase property. So, what the appellate court has said, it is a Stridhan property. There is neither evidence nor pleadings. And the Supreme Court in 1960, Supreme Court 213 paragraph 8 says, when there is neither pleadings or the court cannot make out a third case. My answer is, it is a third case. Then next substantial question, whether the claim of Benami transaction advanced by defendants are satisfying all prescribed. While reminding that your lordship, last time I read Mr. Datta's judgment, the appellate court, first appellate court. Earlier, that order, it is a fit case to remind back the lower court for fresh adjudication by framing an issue on the Benami transaction are discussed above and giving opportunity to the parties to adduce evidence on that score and nothing more. But in the ordering portion, he says, the learned court for adjudication of dispute between the parties appraised by framing issues on the aforesaid discussed grounds relating to the alleged Benami transaction, giving opportunity to both the parties to adduce evidence on that aspect only, and the lower court shall give his findings on the basis of entire evidence. That was the defect.
All right. That's the you are over.
My lord, please.
Avyachi.
Avyachi. And the next was on holiday, 19th May, when the judgment was.
That I've already taken note of.
Your lordship has taken note. Your lordship, I'll just place 2000. Your lordship may turn to 2009 Whaler. 2009 2 Whaler 201 paragraph 38, my lords. It refers to that famous Nazir Ahmed case. When a statute provides for something to be done in that manner.
Particular manner, it should be done in that manner or not at all.
Paragraph 38. When a statute provides for a particular procedure, the authority has to follow the same and cannot be permitted to act in contravention of the same. It has to be adhered to uncontroverted legal position where statute requires to do certain thing. In a certain way, the thing must be done in that way. Other methods or mode of performance are impliedly and necessarily forbidden. Then they Taylor and Taylor, that famous Nazir Ahmed case. Then your lordship may turn to paragraph 46. Here, why I am pressing this, the statute provides that there should be notice before delivery of judgment, and that too in an open court it should be pronounced. Here, statutory provision is there. This CPC is a central act, my lords. It overrides all GRCOs and state civil code, everything it overrides. So this must be strictly complied. It is settled law when the action of the state or instrumental is not as per rules of regulation and supported by the statute. The court must exercise the jurisdiction to declare such an act and illegally invalid. Your lordship may, this paragraph 48 to 57, your lordship may refer to. They've discussed all case laws in India till 2009 it was. Then your lordship, I come to order 41, rule 31.
Points for determination.
Points for judgment. Your lordship, why I am raising this point? About the remand, my lords. It followed Santosh Hazari case, that very famous case. It follows that. But this is very Totiagari, Bhala comprehensive, very urgent. Justice Sadasivan, Justice Hon'Ble judges. Here, why I am placing it? I raised that contention before the first appellate court. That this is not an open remand and it is a limited remand. This has not been answered with points of determination. Before the findings the learned appellate court gave, the 2-line kahile, this is so and this is not a limited remand, it is open remand. What is that reason? What is that reason? And it is cryptic. That is why I am pressing this, my lords.
Yes.
So these contentions have not been answered. But this is cryptic, entire judgment. Then your lordship may come to delay. Delay of 21 days plus 30, 51 days.
Delay means delay of?
Delay in delivery of judgment. 30 days and 21 days. There is no explanation, only that there was COVID. If there was COVID, how the judgment was delivered? There was no, it was a vacation. It was a vacation. Vacation was to take place from May 19th, but courts were closed from May 4th. May 4th or 5th. And the judgment was delivered on May 19th.
Yes.
That is why I praise this 2001 Hon'Ble case, famous and delivery judgment, paragraph 16. They held that judges in India are next to God. And like Caesar's wife, judge must be above suspicion.
Thankfully, they have not said that they are gods.
They are?
I'm
Oh, they are gods. Next to
gods, gods But sometimes we think that we are gods, unfortunately.
In a country like us, where people consider the judges only second to God. Paragraph 20. Still again, dharma avatar ame odia re कहूनो English re process server भी जेतबले दियंती
धर्म अवतार लेखन
धर्म अबिका मु जान्नो जब
ये भी लेखन धर्म अवतार लेख
अबिका लेक्चर
धर्म अवतार जानिबा हेबे अमुक को मुकाम रे जाई पहुंचिला तो से बुदाला पाया गला नहीं तेनु लटका जारी करा गला इत्यादि करा
again.
So that is a civil court language.
Civil court language. से धोती वाला process server au नाम पे गया से language भी नहीं.
So that's all you have completed?
Done. How about
the
conduct of the judges?
Sir, आपन question से देबो.
Again, say
not get into that.
गोटे
से भूल करथाई पारंती
भूल नहीं गोटे मिनिट खाली दो. Again, list of witnesses जेतोळे आपण जजमेंट दउचंती हम मु अपील फाइल करछि list of witnesses witness ना रहिबनी ट्रायल कोर्ट जज रहिए and the appellate court is a district judge. Again, से कौन करछंती DW लेखि नांती से लिखिचंती ना गुडा को witness 3 जण जो एडिशनल लेबे मुझे क्या विरुद्ध कौन it is my duty to look.
No, it's a question of
I don't know those fellows. One is a district judge, one is a additional district judge now. I have heard.
All right.
So this is a fit case, my lord.
Yes.
To interfere, my lord.
Yes, Mr. Sahu.
My lord, I am the plaintiff in the court below. My lord, the genesis of the case, my lord, the land in the name of the mother of the plaintiff and purchased in a registered document in the year of 1958. On 3/1/1958, two sale deed, my lord. Thereafter, 25/11/1959. Thereafter, in the year of my lord 13/11/1977, the father of the plaintiff, my lord, died. And the plaintiff is the, my lord, the status of the plaintiff, my lord, through first wife. And the land in whose name, thereafter, my lord, 1983, 31/3/1983, Satyanarayana Sai, my lord, the father of the plaintiff, retired from his service. My lord, thereafter, in the year of 2005, my lord, that is the, my lord, allegation of the defendant. During the lifetime of Satyanarayana, the plaintiff executed before her father her intention to relinquish her claim over the property by taking 20,000 from her father. That is the unregistered document. Relinquishment of deed. Thereafter, my lord, 2007, the Satyanarayana Sai died, the father of the plaintiff.
and thereafter, my lord, 12/1/2010, the mother of the plaintiff died. My lord, father of the plaintiff, my lord, second marriage, my lord, as per the my lord, version of the defendant, they have pleaded 1977. When the land was purchased in the year of 1958 and 59. On the date of purchase, the defendants not come to the picture of the. Thereafter, my lord, 2010, 2010, my lord, the mother of the plaintiff, Satyavati Sai, died. 2010, the plaintiff filed a suit for right title interest over the suit land and permanent injunction and other consequential paper. And 16/3/2013, and the suit is decreed in favor of the plaintiff. With a direction, my lord, the defendants being unlawful possession over the suit land are thereby directed to give vacant possession of the suit land to the plaintiffs. That is the order passed by the trial court 16/3/2013. Thereafter, the defendants preferred appeal, RFA number 22 of 2013. And that appeal, after setting aside the judgment, the 2013 my lord, trial court judgment has been set aside. They remanded the suit back, directing this to court to dispose of the case, dispose of the suit afresh. Afresh means, my lord, in my mind, my lord, fresh beginning, afresh, by framing of issue Benami transaction. Thereafter, my lord, on 14/5/2015, the suit was remanded, and thereafter, your lordship, kindly see the order passed by the trial court. Specifically, the trial court the lordship kindly see the page 1, 2, 3, 4, 5. Para 4. Be that mentioned here that.
Para 4.
Again, trial court judgment. My lord, civil suit number 95 of 2010.
Yes. Para 4. Be it mentioned here, yes.
Be it mentioned here that after closure of evidence from both the sides and hearing argument from both parties, 16/3/2013, the judgment followed by a decree on 20/3/2013 was passed by this court, decreeing the suit against the defendants. Having been aggrieved by the judgment decree of this court, the defendants preferred appeal bearing RFA number 22 of 2013 before the court of the Honorable District Judge Sundargarh, who, after setting aside the judgment and decree passed by this court, remanded the suit back, directing this court to dispose of the suit afresh by framing issue concerning Benami transaction. Thereafter, your lordship come to my lord, para 5. Basing on the rival contention and direction of.
Let us not get into all these things again, because the point is, according to Mr. Kutia, it was not an open remand, but it was a limited remand only on the point of Benami.
My submissions, my lord, it is opener because the
So
first,
we'll have to go to that judgment again, that remand order.
my lord, say judgment आगे मोर LCR आगे न देखले मो पाखरे आगे से judgment टा नाही. ते जोटा appeal लो जोटा remand हेतला.
The argument will depend on that. Because we have to see
That is, my lord,
what was-
after remand,
No, what was remanded? What was the direction of the court, of the appellate
no,
court?
that has been, my lord, written by the trial court.
No,
The
no,
phrase.
We have to read it independently, because
My-
according
my-
to him, the same observation implies limited remand.
My lord.
According to you or according to the trial court as well as the first appellate court
My lord.
subsequently, that it is an open remand.
My
So let
lord.
us read that portion again. Let us find out what is there. সেটা কেতে ডেট কেতে?
The 15/11/2014.
15/11/2014 It must be available in the LCR. Yes.
LCR.
Yes. Yes. 15/11/2000. Yes. 15/11/2014. Let us go to the operative portion.
Okay.
But it has to be read in its entirety.
It is a feed case.
Run
To
through.
remind, it again page 17 last but 4 line. Page 17 माने जो order पूर्वर it is a feed case to remind the lower court for fresh adjudication by framing an issue on the benefit transaction are discussed above and giving opportunity to the parties to adduce evidence on the score, nothing more. Hence, ordered.
So, what
And my lord, on the my lord, your lordship think about on the other my lord, all the issues, my lord, the prior suit, all the issues, my lord, against him. All the issues, my lord, against me. Your lordship kindly go through the my lord, my lord, जो appeal टा file करथले जो trial court order against रे, that is the my lord 22/3/2013 in CS number 95 of 2010, all the issues against him.
Sure.
And my lord, here is the case, my lord. The first appellate court, fresh adjudication. Fresh adjudication by framing an issue, fresh adjudication. And thereafter, my lord, the word used, framing an issue of and your lordship cogently reading on the trial court judgment. See, say as per the direction of the first appellate court, a fresh and along with additional issue benefit transaction. And thereafter, my lord, thereafter, your lordship, my instruction, my lord, yesterday, my lord, I took instructions whether on the date of judgment passed by the first appellate court,
Yes.
on the holiday or not. My lord, I searched, my lord, the Odisha High Court 22 तारीख ना 23 तारीख रो छुट्टी हेतला. And my instruction, my lord, 19th May 2021 is the working day. Sundargarh.
19th May.
Again. The judgment टा pass हेतला. First appellate court रो जो दिन करथिले 19/5/2021.
This will be a matter of record, whether it was a holiday or not.
My lord, always, my lord, any procedural defect, that is the scrutiny of the court, my lord. I am nothing to say, your lordship, my lord. Any procedural defect, entire LCR before lordships. Well, and thereafter, my lord, your lordship. Kindly turn to page 5 of the first appellate court.
The latest.
সেটা হচ্ছে আজ্ঞা 2015 2021 19/5/2021.
Yes.
Considering the oral and testimony
You
as
are
well
asking
as
for page kete?
page 5.
Page 5.
Page 5 para 7.
Yes.
Considering the oral and testimony as well as the documents relied upon by the parties, the learned lower court decreed the suit of the plaintiff on contest and judgment dated the following grounds. The plea of Benami transaction taken by the defendants as disbelieved by the learned trial court on the ground that the defendants have no legal standing to raise such plea. The learned lower court also considered the plaintiff is the only successor as per the 16 of the Hindu Succession Act. The claim of the relinquishment was disbelieved by the learned lower court on the ground that the same has not been registered as per the section 17 of the Indian Registration Act. Thereafter, my lord, your lordship, come to page 6, para 9. The judgment of the first appellate court passed on dated 15/11/2014 does not disclose it is an open remand, but the entire analysis of the judgment reveals it. So accordingly, the learned lower court framed additional issue, which is as follows: whether the late Satyanarayana Sai purchased the suit scheduled land in the name of the first wife, namely Satyavati Sai, in Benami transaction. Thereafter, para 10. The parties were afforded opportunity to adduce evidence, but the plaintiff did not adduce any evidence further. On the other hand, the defendants examined 3 witnesses after remand. Although para 6 of the judgment of the lower court passed on 14/5/2015 does not disclose this same. But while analyzing the evidence of the witnesses, para 8 of the judgment, the learned lower court has considered the evidence of the said witness, namely so and so, so and so. After analyzing all the evidence on record, the learned lower court disbelieved the plea of Benami transaction taken by the defendants, as the said court did not find any cogent evidence and documents that the property was purchased Benami and the real title holder of as Satyanarayana. The learned lower court further held that the relinquishment deed by Exhibit 5 being an unregistered document, the same cannot be taken into consideration under section 17 of the Registration Act. So my submission before your lordships, they have taken 3 grounds, my lord, all the 3 grounds, my lord. Both the courts found they have not proved all the 3 grounds in 2 courts, my lord. And here is the only question of law. And my lord, all the questions, my lord, all the my lord questions framed by this honorable court, my lord, already discussed before in both the courts.
All right. That's all. Hearing concluded, judgment reserved.
51, that exhibit M, that deed of relinquishment.
Parties may file their notes of submissions and memo citations within a week. Okay. Yes.
That I have said it is a family arrangement which does not require it.
Oh, I have taken note. Last occasion you have said that.
Okay. Aji koinatal to 6 years.
All right. Take.
What a week.
Note within a week. Pass over. Dita. Sir, Dita ji, sir.
So item number 7.
Yes, Mr. Mahdi. Item 7. AD of limitation notice and respondent number 7A not yet received.
ସବୁବେଳେ ଟାଇମ ନଉଛି ନା ଆଜ୍ଞା ମୋର ପାର୍ଟି ଆଜ୍ଞା ଡେଟ୍ ଡେଟ୍ ଅଛି ମେନସନ କରି ଆଜ୍ଞା ଆଣିଛି 15 ମସିହାର ଫାଷ୍ଟ ଅପିଲ ବି ଅନ ଦ ଗ୍ରାଉଣ୍ଡ ଅଫ ଲିମିଟେସନ ଡିସମିସିଂ.
But she is not appearing. Are you appearing for 7 respondent 7A?
ଅଲ ସେମାନେ ସମସ୍ତେ ଏକ୍ସପର୍ଟ ହେଇଯାଇଛନ୍ତି ଏକ୍ସେପ୍ଟ ରେସ୍ପୋଣ୍ଡେଣ୍ଟ ନମ୍ବର 1 ସମସ୍ତେ ଏକ୍ସପେକ୍ଟ ହେଇଛନ୍ତି
ଏକ୍ସପର୍ଟ ହେଇପାରନ୍ତି ଆଜ୍ଞା ବଟ୍ ଏଇ କୋର୍ଟରେ ତାଙ୍କ ସମସ୍ତଙ୍କ ପାଖକୁ ଅର୍ଡର ମାନେ ନୋଟିସ ଯିବା ପାଇଁ କୁହାଯାଇଥିଲା so let us see what has happened to the postal tracking report
ସଫିସିଏଣ୍ଟ ହେଇଥିଲା
notice is sufficient
ମାଇଲର
postal tracking report has already been served there is how no appearance
ସମସ୍ତଙ୍କ ଉପରେ
so what is this for limitation
ମାଇଲର
so we'll condone the delay
ମାଇଲର delay is 4 years ମାଇଲର
ହଁ ସେ
ମାଇଲର kindly see ମାଇଲର
କଣ ଅଛି ମ୍ୟାଟର କଣ ଅଛି substantial matter କଣ
for partition ରେ we are the plaintiffs ଆମର
against confirming or reversing judgment
partition suit ଟା dismiss
ହେଇଥିଲା
ଆମେ appeal ଗଲୁ appeal ଟା delay ground ରେ
dismissal yes
ଆମେ କହୁଛୁ partition suit ଟା maintain ହବ ତାରି ଉପରେ
appellate court dismissed your appeal on the
ground of limitation
so you challenge that with again after 4 years
after 4 years
ନା କେତେ ବର୍ଷ ମୁଁ ସେଟା
yes my lord
ମୁଁ ହିସାବ କରି ଦଉଛି ନା
9 ରେ just
1246 days 1246 दिन डिले ମୁଁ ସାରି ଦଉଛି ଏଠି
ମେଡିକାଲ ସାର୍ଟିଫିକେଟ ଦେଇଛି
ମାନେ ମେଡିକାଲ ସାର୍ଟିଫିକେଟ ଆପଣ ଦେଲେ କଣ ହବ ଏଠି ସାରି ଦଉଛି
ଟିକେ ରହୁଛି ମୁଁ
ରହିବ କଣ
କଣ୍ଟାକ୍ଟ କରୁଛି ସେ ଫୋନ ଟା ଛୁଟି ପରେ ଆସୁ ଛୁଟି ପରେ ଖାଲି ଆସୁ
नो 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 ସାଙ୍ଗେ ସାଙ୍ଗେ ଏଇଠି ସାରି ଦେବି 2013 ର ଲିମିଟେସନ ପୁଣି 4 ବର୍ଷ ପୁଣି ତଳ କୋର୍ଟରେ ବି ଲିମିଟେସନ ଗ୍ରାଉଣ୍ଡ ଡିସମିସ नो नो नो
ସାର୍ ଆମର ଗୋଟେ ମେଡିକାଲ ସାର୍ଟିଫିକେଟ ଦେଇଛି ଦେଖନ୍ତୁ
ସରି ମିଷ୍ଟର ମହାନ୍ତି ଆଇ ୱିଲ୍ ପାସ୍ ଅର୍ଡର ଡୋଣ୍ଟ वरी ଆଇ ଏଇଠି ପାସ୍ କରୁଛି ଅର୍ଡର ଆପଣଙ୍କ ଆଗରେ ଆଇ ଏ କେତେ
16/6/23/9
केस नंबर 5 of 2013
ସାର ଦବା ଆଉ
ଟିକେ ମୁଁ ମେଡିକାଲ
ନା ନା ମୁଁ ଦେଖିବି ହଁ ଦେଖିବାକୁ କହୁନାହାନ୍ତି କୋର୍ଟ ଦେଖିବା କଥା
ଦେଖନ୍ତୁ ସାର୍
ଦେଖିବି ଆପଣ ଆର୍ଗୁମେଣ୍ଟ କରିବେ ଶୁଣିବି ସବୁ କରିବି This is to certify that Sri Shankar Sahu, aged 78 years, son of late Sanatan Sahu, village Athe, Patkura Kendrapada, has been suffering from rheumatism with hypertension. ଗୋଡା ତ ବିନ୍ଧାବିନ୍ଧି ହଉଛି
ଯୋଉଟା ଦେଇଛି ସାର୍ ମୁଁ
ଦେଇଛି ମୁଁ ସାଙ୍ଗେ ସାଙ୍ଗେ ରିଜେକ୍ଟ ଆଇଏ ମିସ୍ କେସ୍ 5 of 2023 this is an application for continuation of delay in filing the appeal. Stop. A medical certificate has been enclosed to the IA. It is stated that because of old age ailments, the appellant could not contact his lawyer nor could take steps to obtain the certified copy of the judgment and decree for the purpose of filing the appeal. In the process, there has been delay in filing of the appeal. Ms. Mamata Mishra, learned counsel appearing for the respondent number 1, has opposed the prayer for condonation by submitting that the delay has not been properly explained, and moreover, the first appeal preferred by the appellant was also rejected on the ground of delay, on the ground of limitation. This is, office has pointed out delay of 1246 days. After going through the medical certificate enclosed to the application, this court finds that the appellant was suffering from rheumatism with hypertension as certified by the doctor and was under treatment from 16/6/2009 to 23/9/2012. There is nothing in the certificate to indicate that he was unable to move about.
He has been advised for rest.
Though there is a mention that he was advised rest. The medical condition is such, the medical condition as described in the certificate is not such as would prevent a person from discharging his daily duties. Moreover, the conduct of the appellant is also a thing to be considered, in as much as the first appeal preferred by him was also delayed and was rejected on such ground. Stop.
appellants prefer them.
Yeah. Appellants for what? Appellants. Taking into consideration the above facts, I am not inclined to condone the delay. Yeah. Which is the application is therefore rejected. Stop. Consequently, the second appeal also stands dismissed. Yes. So Sundar Sariala, kai vakata bro. Sundar Giri Sariala. Yes.
Sir, item number 16. I'm taking a short pass over, Milords. Mr. Mishra is in selection Chief Justice Court.
Well, since yesterday I've been hearing about Mr. Mishra, but I'm unable to see
Mr.
him.
Mishra was sitting here just right. Was waiting for his.
All right, pass over. Admission dako. Admission aramindo? Aramu dakti?
Item number 17.
It admission item 2024 or 14 admission. It has not been admitted as yet.
In fact, it is a transfer bill.
No, but
Today I'm appearing for respondent.
you may appear. You may appear.
My friend is appearing for respondent.
No, let him appear, but let us see.
Your Lordship, kind.
No, sir. No, sir. On 15/10/2015, because the appeal is admitted on the substantial questions of law as indicated in ground number A of the memorandum of appeal. It a hearing question.
Hearing.
Has the LCR is available?
LCR is there. LCR is there. So what
hearing pe nahi
so what happened in the meantime? He filed a miscase for repairing of the house. Now, by name of repairing, he has cast a roof 2,200 square feet or chhata pocket.
Is there not there is no status quo order?
There is a status quo order.
So you file a petition for violation?
Madam, I'm filing, matter will be called next week. Madam.
You file a petition for violation?
I'm filing the.
No, what we will do is.
Madam.
All right, you file a petition for violation, we'll see.
Violation as well as fresh injunction application.
Obviously.
Otherwise, madam, he has already casted a roof in the name of, since appeals are not taken up. Status quo was there.
The appeal was admitted on 15/10/2015 on the substantial question of law as indicated in ground number A of the memorandum of appeal. Said ground.
B is also relevant.
No, se ja heichi ho to change kara hoga.
Your Lordship, can I at any time also?
I can.
At page 8.
Memorandum of appeal to
Memorandum of appeal 364.
No, you see, it is not your mistake. This is a mistake of our scanning agency. So एमिति कर दउछन जे जना पुनी को जगह कोटा में रखि दउछन so every time I have to find out miscase को आगे रखछन नहीं ना is arrested.
You can take my brief.
No, but let me find out. It must be there in the record.
Yes.
It has to be on record.
Yes, it has to. Soft copy demo, actually it is there. It can it is not in a proper manner. Hard copy
The judgment is of 30th April 2014. RFA 13 of 2007 though. Oh, ठीक है चुसता वाला. But where is the second appeal memo? Memorandum of appeal ठीक है देखो. ना इधर खाली ये राशि judgment है.
RFA is 13 of 17. Lordship can report my brief.
Let me just find out, man. It is very strange. Babu, what are they? Where is the RSA? RSA petition ରହିଲାଣି କେତେ ପରେ ଦେଖ କଣ କଣ ସବୁ କରିକି ତାପରେ RSA petition ରଖିଛି
Our internal page.
The second, the substantial question of law earlier framed is reframed in the following manner. Sir, so Aguru sir, Supreme Court question, but you have to frame the entire question. Kali question number 1, 2, 3, 4 kardala haboni. Page 8 ro.
Page 8. A. Whether the learned court below.
It will be done. Let's this matter. When do you want?
Immediate matter. Next week I have some urgency because.
Let's this matter next week as prayed for.
Today I am appearing.
Yes.
Respondent number 3 and file IA for transposition.
In fact, he is my brother. I am the
Sri Saubhagya Kumar Ratha advocate has entered appearance for the sole respondent.
No, there
Respondent number 3.
There are 3 respondents. 2 died. Respondent 2 died, and he should be deleted from the.
Respondent number 3 has appeared for respondent number 3.
I am also filing.
He also files an IA for transposition of respondent number 3 as appellant number 2. The same be registered and kept on record. Let's this matter next week. Yes.
The respondent number 2 is dead in the meantime.
In the meantime, respondent number 2 has died, but he need not be substituted.
On record already. He already appellant he
Since his LRs are already on record, no substitution is necessary.
Well,
the name of respondent number 2 be deleted.
Since date he consolidated.
Since date is settled.
I will file the consolidated.
Yes.
Transposition
Item number 18.
May I please, Your Lord?
This has also not been admitted.
My Lord, this has not been admitted, Your Lord.
How? Oh, there were some defects, that is why. Deficit court fee has been paid.
My Lord, now it is defect free. 17/9/2019 it has been paid.
All right.
My Lord, I pray, my Lord, Your Lordship may kindly accept the same in the miscase that has been filed. Otherwise, that will create problem, my Lord. IA 653 of 2019 at flag A for acceptance of the court fee, that will regularize the appeal.
It is stated that court fee is worth rupees. The balance court fees of rupees 1105 has been paid on 12/9/2019. Office to verify and accept the same.
May
IA is disposed of. Yes.
May I please, Your Lordship?
Yes.
My Lord, the defendant number 127 are the appellant.
Defendant number?
127 are the appellant.
Yes.
Against confirming judgment. Suit was filed for declaration of right title interest, permanent injunction, and for other consequential relief. In fact, the case of the plaintiff was based on the premises that the one Kamal was the exclusive owner of the property in question. Kamal sold 4 acres 94 decimal to Giridhari and Mrityunjaya on 21/1/1928. Thereafter, it was mutated. But then Giridhari purchased the property out of joint fund. Giridhari's younger brother Guru got the property in view of registered partition deed of the year 1947. Now, Giridhari's brother got the property by virtue of partition, Guru. Now, Guru died and he was succeeded by 4 sons, and they sold 1 acre 24 decimals of land to Niranjan. And there the issue will arise so far as the case is concerned. Now, this was sold by virtue of a sale deed of the year 1965. Now, this is a question was raised with regard to whether there has been fraud on registration or not. By Exhibit 3, the sale deed is the source of title from by virtue of which Niranjan sells the land to the plaintiff through Exhibit 4. Now, Exhibit 4 has been registered at a place by including a property, and that has been discussed. I will point out that by including a property which is not within the jurisdiction of the measure of the properties for which the sale deed has been executed. For example, I will say the properties are of Cuttack, 1 decimal of land of Bhadrak
has been included in the cell deed and the cell deed has been registered at Bhadrak. That 1 decimal of land, my lord, from the records, there is nothing that that property belongs to the person who has sold. Therefore, there is fraud on registration. So, therefore, on the basis of that Exhibit 4, the plaintiff cannot derive title so as to claim declaration of right agency. This is one part of it. And that has been brushed aside, my lord, by the learned court below, saying that I cannot raise. Then one more aspect that was found out is that some Mighty was recorded and they are not Mahanti, which is the case here. But the court, appellate court says Mighty, Mahanti might be wrongly recorded, so therefore they are one and same person. That is how the appellate court has proceeded to reject the same. There are two aspects in the case.
You are right, but in North Baleswar, Joleswar area, what is Mahanti on this side becomes Mighty on the other side. That is Midnapur. That is why they may, but Mighty is Mighty, Mahanti is Mahanti.
Here he has proceeded on the assumption in the absence of a material.
Yes, yes.
So that may give back to a forward finding.
But the court cannot take judicial notice of it.
And that should have been some kind of existence of material.
Yes, yes, obviously. As I said, I know, but I cannot take judicial notice of it.
Here the learned trial court has done what it has done. Exhibit 3 has been accepted, that 1928 document, my lord, which I was placing the sequence of events, to be a 30-year-old document, therefore admitted, though no proof was made. Because it was accepted without objection, it has been accepted. One of the questions I beg to raise for your lordship's kind consideration, though not formulated in the appeal, is that whether in the absence of any other proof, merely because a document is 90 years old, 30 years old, more than 30 years old, will be on the face of it accepted, including the contents thereof, in terms of section 90 of the Eviction.
Corroboration is necessary according to you.
Kind of material. It is not that merely because it is 30 years old, it automatically gets admitted and the content thereof gets proved.
A presumption can be raised, that's all.
Much obliged, my lord. Presumption is far different from a proof, my lord. That is what I beg to humbly submit. This is one question I beg to raise for your lordship's kind consideration. The second question would be apparent fraud on registration. Namely, the cell deed and this registration at a different place where the property doesn't belong will amount to fraud on registration. These are the 2 points I beg to raise for your lordship's kind consideration.
What did the appellate court do?
Appellate court, my lord, your lordship kindly see. That point was raised at paragraph 8, page 6, your lordship. And that Meiti, and that was raised also. Apart from that, fraud on registration also, your lordship will find towards the last portion. The learned appellate court deals with it at page, after taking note of the judgments and everything, formulates the point at page 8, paragraph 10, your lordship. Then that Mighty and Mahanti has been, my lord, which your lordship was pleased to observe, has been also formulated. Then the court deals with Exhibit 4 at page 11, paragraph 15. That property of Ramnagar was included. That's completely different, 0.01 decimals to make the registration there. So apparent fraud, your lordship. And that has been brushed aside, your lordship.
Who is there?
Madam?
2, substantial question number 2. You grounds upon raise करते.
2 is there, fraud on registration. My lord, the other one I was saying that 90, section 90, whether Exhibit 3. Fraud is with regard to Exhibit 4, my lord. I have not mentioned that in the ground. Therefore, I was making a submission. But that has become little vague. I may be pardoned for that.
Heard Sri Samir Kumar Mishra, learned in counsel with
Jagajivan Pradhan.
With Sri Jagajivan Pradhan for the appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. One hela. Ground number 2 taku 1 will lekha page 10 re. Ago to kon koile apuno?
That 2 ta 1 was Exhibit 4, fraud on registration ta.
Maybe it exhibit to kichhi lekha hai nahi.
Exhibit 4 ta
exhibit 4 hobo, hai na?
exhibit 5 ଲେଖା ହେଇଛି
I
ସେଟା
mean,
exhibit 4
warrant for
କରବ
that.
ହେଲା ମନେ କରିକି ତ ଆରଟା ହେଲା regarding that
That
30
exhibit
years
30 years old ବୋଲି automatic.
whether the courts below were correct in accepting exhibit 3 as a valid document only on the presumption of its correction, only because the same was 30 years old,
Yeah.
without there being any corroborative proof there too. That's all. Issue notice to the respondents by registered post, returnable within 4 weeks. Requisites be filed within 3 working days. LCR be called for. Is this matter on?
ଶୀଘ୍ର ରହିବ ଅକ୍ଟୋବର ଲାଷ୍ଟ
No, October last to February.
ଆଜ୍ଞା ନଭେମ୍ବର ଫାଷ୍ଟ ୱିକ୍ ଆଡକୁ
In the week commencing 11th November.
Obliged.
Item number 19.
Item 19, pass over the matter.
Item 19.
My lord, item 19 is pass over.
It's for admission, your lordship. Learned senior is on his legs.
Okay, pass over.
Item number 20.
My lord, item 20, I prefer an adjournment, my lord.
All right. Is this matter in the week commencing?
Say no, we commencing 18th November.
18th November, yes.
Item 21.
21, Mr. Ghosh was here, yesterday was mentioning.
My lord, I'm appearing not in 21, lord.
Yes.
My lord, the defendants are the appellant before lordship, my lord.
Yes.
In a suit filed by the, my lord, respondent number 1 for declaration of right, title, interest and permanent injunction before the learned civil judge, Junior Division, my lord, at Jagatsinghpur. My lord, the plea was that there was a joint recording in favor of, my lord, in the one Mr. Ponda family and, my lord, another Behra. And that Behra sold the land to the plaintiff, the respondent. And the Ponda family sold the land to, my lord, this respondent, the present appellant's, my lord. The sale of the Behras was 2013 and to the appellants in 2014, my lord. Well, in that suit, in the plaint, there has been a specific mention about the consolidation in the written statement. In paragraph Roman 7, there is a specific mention about the consolidation happening in the locality, my lord. And thereafter, the suit was decreed without any issue being framed with regard to consolidation. And without any further issue being framed with regard to how could the Behras, their name got recorded in the 1985 record of right. Admittedly, the property belongs to the party, to the Pandas, which has been recorded in the 1930 record of right. Well, there is no pleading, nothing, but based on certain statements with regard to one OEA case, about which there is no mention, no document, nothing, Malad. That Behra's name was recorded jointly with Miller Panda. Based upon that, the suit was decreed, Malad. With regard to but the suit for injunction, prayer for injunction was rejected. Then the lower appellate court, Malad, framed one additional issue. And after framing one additional issue, decides by himself, which is barred under order 41 rule 25, Malad. So, and also my appeal before the lower appellate court was rejected and the suit was decreed in full, against which I have come, my lord. Lordship will see substantial questions of law at page 31, my lord. Page 31, my lord. Page 30, my lord.
2 will be there.
Yes, 1 and 2 both will be there, my lord. 1, 2 and 3 also. And interestingly, I will take a lordship to one particular page, lordship just sees page 56. I'm sorry, not page 56, page 52, Malad.
Yes.
Lordship just sees this is the finding paragraph 16, this suit primarily based on documents and there is marginal importance of oral evidence. The evidence of the 3 witnesses of the plaintiff and the 4 witnesses of the defendants do not hamper my efforts and observation and finding. The learned counsel for the parties also did not lay stress on the oral evidence. Hence, I avoid to enter into the detail and critical appreciation of the oral evidence adduced in the suit. Is it possible?
But she says that's the senior counsel with, who is with you?
Mr. Ghosh Milan.
With Mr. P.K. Ghosh, learned counsel for the appellant. There is the impugned judgments. Considering the submissions, the second appeal is admitted on the following substantial questions of law. Page 30, 1, 2 or 3. Issue notice to the respondents by registered post with AD, returnable within 4 weeks. The requisites be filed within 3 working days. LCR be called for. Is this matter?
Commencing 9th December, sir.
In the week commencing 9th December. Yes.
When I have an interim prayer for injunction, let the status quo be maintained, my lord.
Sir? Yes, yes.
When I have an interim prayer for injunction, my lord.
900. IA 900 of 2023.
No, I am in possession, my lord. Let there be status quo with regard to possession.
IA 900 of 2023. It is directed that status quo with regard to the suit property shall be maintained till the next date.
Obliged.
Yes.
Item 22.
कितना अच्छे एडमिशन? What is? अपने पास में होगा.
In fact, the defendants are in appeal against a confirming argument. It's a suit for permanent injunction simplicity. There is a genealogy at page 7 of the memorandum of. Kindly have a glance at the genealogy, so that the status of the parties can be ascertained.
Yes.
The original owner is Hari Swain. Then he had 3 branches: Ananda, Panu, and Paramananda. The plaintiff's branches are Ananda and Panu. Panu's successors are plaintiff numbers 1 to 3. Then others from 4 to 10 are there. They are the successors of Ananda. So the 2 branches represent the plaintiffs. Now the Paramananda's branch, he was succeeded by one Nidhi. It is claimed that this Nidhi died in the year 1929. So he left behind undisputedly one son Indramani, then Uchchava is another son, then Para is the daughter. There is a dispute with regard to the fact as to whether Uchchava had any legal heir or not in the before the trial court. But the fact remains that the Para left behind his 2 sons, Dhadi and Narahari, who were defendant numbers 1 and 2. Then the other defendants are the purchasers from 1 and 2. All of them are contesting jointly. The claim of the plaintiff is that there was no partition.
Who was the plaintiff then?
Plaintiff's branch is Ananda and Panu.
Okay.
They both of the branches are plaintiffs.
Okay. Okay.
So the claim was that this Nidhi, he expired in the year 1929. Thereafter, undisputedly also Indramani died issueless. Plaintiff also claimed that Uchchava also died issueless. Therefore, the only heir is Para, who remained as a daughter heir. Since Nidhi had died in the year 1929, therefore, no right can be accrued. So the sale made by Dhadi and Narahari should be declared illegal. So there was no partition, the property would devolve on the other 2 branches. Now the defendants appeared, they claim that in fact, there is no dispute that Indramani had no legal heir. That issueless. But it is the claim of the defendants that Uchchava expired leaving a son Surendra. I have therefore highlighted the name of Surendra. And Surendra expired issueless. There is no dispute. So it is claimed that even if this Nidhi expired in the year 1929, as a heir of Uchchava, Uchchava had a son, Surendra. Surendra's property, or the property which was inherited by Surendra, that will devolve on para.
But this is prior to 1956?
Prior to that is admitted. So that is one of the major questions which was required to be answered by the courts below. But it was ultimately held that para cannot inherit the property. In fact, para, the defendants say it is the sons of para who will inherit the property. Whether that will be permissible or not under the old Hindu law or not, that is major question. Now kindly have a glance at this. I am just referring to Article 46.
Because of limited ownership.
No, it will be absolute under the old Hindu law.
No. That is what they have said.
They have said the para will have no share because as a daughter she cannot inherit.
Okay.
Limited ownership could have come if
Yes.
Nidhi's wife would have been there. Article 46. So that Article 37 onwards deals with the direct inheritance of the male heirs. Now here is a case, undisputedly there is one, if the plaintiff's case is accepted, then there is only one heir, para. And if Surendra will be a son, which has been accepted by trial court as well as by the appellate court, concurrently found that there is a son, Surendra. If Surendra is found to be a son concurrently of Uchchava, then whether the two sons of para will inherit or not, kindly have a glance 46 of article.
Difficult to understand. Anyway, so we'll deal with it at the time of hearing.
That is one of the questions I have raised. Because father's sister's son will come in absence of any other heir.
As Pitru Bandhu.
Atma Bandhu. The first one is father's sister's son. Because no other heirs are there.
Pitru Bandhu habo dekhle?
It have Atma Bandhu.
Dekhle? Atma Bandhu. Atma Bandhu list ଅଛି. Father's sister's son. ମାନେ ପିଇସି ଙ୍କ ପୁଅ. No, father's sister.
So this aspect of the matter has not been taken into consideration by either of the trial court and the appellate court. I have clearly raised it. So ultimately it is held that Nidhi, after the death of Nidhi, para will not inherit. Therefore,
So the suit was decreed.
Suit was decreed, permanent and appellate court confirmed. Second one is partition, whether there is a prior partition or not, because it is claimed that the three branches had already partition. Several documents were filed to show even the plaintiffs are not staying in that village, they belong to a different village. Those documents are also filed.
All right. So we'll take up.
I have and one aspect, because that is there in the grounds of appeal. An earlier plaint was filed also, which was exhibited, Exhibit A, in which one of the plaintiffs who were participating in the earlier suit, he also admits that there was a prior partition. There also it is admitted that Surendra is the son of Uchchava. Learned trial court as well as appellate court accepted those plaints so far as the sonship of Surendra is concerned, but is negating the
prior partition.
So far prior partition is concerned. So those two grounds are only perhaps indicated C, D and E.
C रे D टा cover ହେଇଯିବନି?
Exhibit A ऊपर चले जाओ.
E टा तो ରହିବ?
E टा ରହିବ.
Okay, C, D and E will take it up. Heard Sri D.P. Mahathi, learned counsel for the petition appellant, peruse the improved judgments, considering the submissions and the grounds raised. The second appeal is admitted on the following substantial questions of law. page 13 रो C, D और E है ना? Issue notice, sponsor कर दो. Call for the LCR. List this matter on. आइए, notice as above. Accept one set of process fee. कौन मागी चिंती?
possession कारण से purchase करनी 1963 रो. possession टा बर्तन disturbance होच.
Status quo.
Status.
Status quo as on date shall be maintained till the next date. Status quo with regard to the suit property shall be maintained till the next date. Yes.
Posted to December.
Posted.
9th December.
I don't know, 23.
Shut up. He's not there. Pass over. देखिए कल जाए ना. He is not there. मैं pass over किंतु करेंगे. He may come up tomorrow.
24.
Last week also he was not there.
Tomorrow remind me if he doesn't appear. 24.
Here, challenging the order, the judgment that decree passed by the learned civil judge senior division Dharmagad and which is confirmed by the learned ADJ. And admittedly, the fact means the sole question is to be decided by this honorable court whether the property inherited from the male Hindu, whether the ancestral property and whether the property inherited by the female Hindu is a separate property. That question I was raised in the trial court, that has not been answered, and specifically in the ground itself, and it has been quoted in the appellate court judgment that I have raised. I have admittedly the facts remains. Apurva Mulani was the purchaser of the property. He was recorded in the 56-57 record of right, and after her death, the land was developed in favor of Tonkadhara Naik and Chaturbuja Naik. They have been separately recorded during settlement operation. And after coming to in favor of the Tonkadhara Naik executed the sale deed in favor of different respondent number 6. He was died in the meantime and he has been substituted. And after his death, he was executed sale deed in the year 2009, which has possession has been delivered, and thereafter, for legal necessity, that Dharmaraj Padi has executed sale deed in favor of the appellant. And admittedly,
appellant is defendant number?
Defendant number
3 na 1.
2.
Okay. Then
I have raised that point. It's an exclusive property of the Dharmaraj since it has been inherited from her mother.
So both the sale deeds were declared to be invalid. Then what happened in the appeal?
Appeal I have raised and ground I have stated in page 14 of the judgment.
Internal page 14.
Yes, page running page 26. Yeah. That when it is a specific case of the plaintiff respondent number 1 and 2, that defendant number 3, respondent number 3, that the schedule A land inclusive the schedule B land is the purchase land of the Apurva Mulani. The late mother of the defendant number 3 was exclusively recorded in the name of late Apurva Mulani in 1956-56 Savit Settlement Revived Exhibit 1. It is evident and well proved that the schedule A land inclusive of the schedule B land was the self-acquired exclusive Stridhan and absolute property of the Apurva Mulani, the late mother of the defendant number 3 and respondent number 3. And after death of Khageshwar Naik, the father of the defendant number 3, respondent number 3, schedule A land inclusive of the schedule B land developed only to the defendant number 3, respondent number 3 as legal heir. And on this score, the learned trial court has not legally justified the holding that the suit for schedule B property and A property land, ancestral property of the plaintiff respondent number 1 and 2, and defendant number 3 and 4 and 3 to 5 and respondent number 3 to 5. The judgment of the decree and learned trial court is to be dissatisfied. Admittedly, the daughter here of the Tonkadhara has filed the suit for declaration of the right title interest along with the cancellation of those sale deeds. We have specifically raised that point. It's an exclusive property of the Tonkadhara. You have no right to challenge that property. And during the lifetime of the Tonkadhara, you have the succession has not been opened in survival after during pendency of this Tonkadhara. But still then the land trial court has dismissed my appeal and without touching that point also. And thereafter, I specifically in the ground itself, I am appeal, it has been raised. But the land appellate court also has not been considered.
You can say B.
Yes, B
and C.
Yes.
B, C and D claimant position. B, C and D will also.
Yes, yes, yes.
B, C, D, E. The you are Mr. Rautray.
Yes.
Heard Sri A. Rautray, learned counsel for the appellant. Peruse the impugned judgments, considering the submissions and the materials and the grounds raised. The second appeal is admitted on the following substantial questions of law. Page 10 row. B, C, D, or E. Issue notice. Call for the LCR. List this matter on?
Commencing 16th December.
We commencing 16th December. Yes. Status quo. Status quo with regard to the suit property shall be maintained till the next date. Notice as of Item
25.
Dear my lord, in a suit for partition, suit was decreed. I was defendant 5, I contested. My only point is I have purchased some 12 division land from defendant 3 that may be determined in my share. That has not been made. So I filed appeal. In appeal.
No, who are you?
I am the defendant 5.
No, defendant 5 means you are one of the co-sharers.
Yes, sir. ଆମ ଭିତରେ ଯୋଉ ଇଣ୍ଟରେଷ୍ଟ ଟ୍ରାନ୍ସଫର ହେଇଥିଲା 12 ଡିସମିଲ୍ ମୁଁ ଖରିଦି କରିଥିଲି ଡିଫରେଣ୍ଟ 3 ଠୁ ତାକୁ ବି କେହି ଅବଜେକ୍ସନ କଲେନି ମୁଁ ବି କଣ୍ଟେଷ୍ଟ କରି ସୁଟରେ କବଲା ଦେଲି କିନ୍ତୁ ଡିଫରେଣ୍ଟ 3 କଣ୍ଟେଷ୍ଟ କଲାନି ସେଇ ମୋର ସେ ସେୟାରଟା ଡିଟରମିନ୍ ହେଲାନି ମୁଁ ଅପିଲ କଲି ଅପିଲଟା ଡିଲେ ଥିଲା ସେ ଡିଲେ ଗ୍ରାଉଣ୍ଡରେ ଅପିଲଟା
ସବୁଗୁଡା କଣ ଡିଲେ ହଉଛି
କଣ କରିବି ଯାହା
ଦେଖିଲି ସବୁଗୁଡା ଡିଲେ ହଉଛି ସେ ପ୍ରଥମଟାରେ ଯାହା ଫେଟ୍ ହେଲା ସେଟାରେ ସେୟା କରିଦବା
ନାଇଁ ଏଇଟା
କଣ ଡିଲେ ହେଇଛି ଦେଖିବା
ଅପିଲ ସାର୍ ସେକେଣ୍ଡ ଅପିଲ ଡିଲେ ନାହିଁ
ଫାଷ୍ଟ ଅପିଲ ଡିଲେ ହେଇଛି ତ ସେଇଟାକୁ ତ କନସିଡର ଆମେ କଣ୍ଡୋନ କରିବା ନା ନାଇଁ
ନାଇଁ ସେଇଟା ସାର୍ ଟିକେ ସେଇ ଗ୍ରାଉଣ୍ଡରେ ଆଡମିଟ୍ ହବ
ନାଇଁ ଆଡମିଟ୍ ତ କରିବା କି ନାଇଁ ଦେଖିବା ରୁହନ୍ତୁ କଣ ପାଇଁ ସେଇ ଗ୍ରାଉଣ୍ଡରେ ଡିଲେ ହେଲା ସବୁ କେସରେ ଆପଣଙ୍କ ଡିଲେ ମୁଁ ଦେଖୁଛି
ସାର୍ ହେଇଛି ସାର୍ ମୁଁ ନେଇଛି କିନ୍ତୁ ସେ କଣ କଲେ ନା ଆପେଲେଟ୍ ଜଜମେଣ୍ଟ ପାରାଗ୍ରାଫ 9 ରେ କହିଲେ
ପୁରୁଣା କଟକର ଯୋଉ ସିଭିଲ ଚାମ୍ବର
ଆଜ୍ଞା
ତା ଭିତରେ ଆପଣଙ୍କର ଜଣେ
ଆମର ହଁ ଥିଲେ
ହେଲା ଆପଣ ସେଇ ସ୍କୁଲର
ଆଜ୍ଞା
ମିଷ୍ଟର ମହେଶ୍ୱର ମହାନ୍ତି ବିଲଙ୍ଗସ୍ ଟୁ ଦ୍ୟାଟ୍ ସ୍କୁଲ
ସାର୍ ମୁଁ ଗୋଟେ ଦେଇଛି ଆଡିସନାଲ
ନାଇଁ ଆଡିସନାଲ ଫେଡିସନାଲ କିଛି ନାହିଁ ସେଇଥିରେ ତ କରିଦବ ଆଡିସନାଲ କଣ ହବ
ମୁଁ ଗୋଟେ ଭଲ ଭାବରେ କରିଦେଇଛି ପେଜ 2 ରେ ଦେଖନ୍ତୁ ଏଚ୍ ଗୋଟେ ଗ୍ରାଉଣ୍ଡ ଦେଇ ସେଇ ଗୋଟିଏ କରିଦେବା ଆମେ ଯୋଉ ଲିମିଟେସନ ପିଟିସନ ପ୍ଲିଡିଂ ନେଲୁ ତାକୁ ସେ ପାରା 9 ରେ କିଛି କହିଲେନି କହିଲେ ହାର୍ଡ ଡିଲେ ଇଜ ନଟ୍ କମ୍
ଏଚ୍ ଯୋଉଟା କରିଛନ୍ତି ସେଇଥିରେ କରିଦବା
ଆଜ୍ଞା
Heard Sri Maheshwar Mathil, counsel for the appellant.
He appear କରୁଛନ୍ତି respondent 1.
You are appearing. So let me admit it. ଯୋଉମାନଙ୍କ ପାଇଁ appear କରୁନାହାନ୍ତି ତାଙ୍କ ପାଇଁ notice ଯିବ ହେଲା Heard Sri Maheshwar Mathil, counsel for the appellant. Peruse the impugned judgments, considering the submissions and the grounds raised. The second appeal is admitted on the following substantial question of law. You have, Mr. Mahanti, you have appeared for respondent? Only 3. Sheikh Jakub Bakkar. And for others, have you? I can. If you can appear, then there will be no notice.
I will appear from the others also.
Sri D.P. Mahanti has already entered appearance for respondent number 3. Hence, no notice need be issued to him. Sri Mahanti further undertakes to appear for all the other respondents.
No, not all.
How?
Abu.
Oh, see you.
I will take notice to 4 to 11.
Sri Mahanti undertakes to appear for respondent numbers 1 and 2.
Not be necessary 4 to 11.
No notice need be.
No, sir. 5
no notice need be issued to them. Adequate numbers of appeal memo be served upon Sri Mahanti. So, issue notice to the respondent numbers 4 to 8. Let him take notice. 4 to 11, sorry. 4 to 11 by registered post. Returnable within 4 weeks. Requisites be filed within 3 working days. LCR is necessary in this case.
Day of final degree.
LCR be called for.
Final degree participate
आइए in the interim it is directed that final decree proceedings shall continue, but the decree shall not be sealed or signed till the next date. Let's this matter on call break. 16th December.
Aye.
Yes.
Item 26. खाली ଗୋଟେ copy दा.
Order each. देखिए adequate numbers of copies. Yes, item 26. Yes, Mr. Mishra.
This suit for petition. Plaintiff before me, Lord.
You are the plaintiff.
I am the plaintiff.
Yes. Suit for partition.
Suit for petition. The only common ancestor one is Vishwambar, who has two sons. One is Magadha, another is Agadhi. Magadha has no issue, I mean no male child. He adopted the one of the son of one Simanchal. Has adopted this. And that adoption has been, though has been accepted, but it is a new adoption, not that old law is governed. Fact remains, the London trial court held that this is not an ancestral property, as well as the appellate court held that it is not an ancestral property. Only one ROR has been exhibited, that is exhibit 1. It's a consolidated ROR recorded in name of all the legal heirs of that Vishwambar, including the plaintiff and the defendant number 1. And it is published in the year 1995. The London trial court exceed the jurisdiction to that the consolidation ROR has been prepared in wrong, even though it is prepared in the year 1995, because the consolidation authority under section 44 of the Act itself has the jurisdiction, has the power governed by the civil code, right, title and interest. When it is prepared in the year 1995 jointly, and all have participated there, then the London trial court now disbelieve in the year 2019 that is not a joint family property, it is a self-occurred property. And the commissioner has committed a wrong recording the land in jointly. The first appellate court held that it is not an adoption deed, it is an adoption deed along with a gift deed of the year 1966. While the defendant number 1 was 10 years old. If it is 10 years old, then the Adoption and Maintenance Act 1956 will be governed. There is no witness at all, and there is no giving and taking ceremony. One line, a widow has adopted a male child. In the latter part of that deed, Exhibit A, he has made him petition and said that I have donated these properties. That is the reason why the London courts will has held that is an ancestral, not an ancestral, but a self-occurred property. Second point they have held, there is a earlier petition. Your Lordship, there is no document at all, either by all the sides, that there is an earlier petition by metes and bounds by or any other means. Trial court held that there is a petition, hence there is no necessity at all for further petition. But the wrong committed by the plaintiff on PDL 1 said that there is a petition. That is the crux only.
Why have you said that the amending provisions of this Consolidation Act has no retrospective effect? How is it relevant?
Relevant because there is a question of fragmentation. There is a wrong has been typed there.
You section 37?
Yes. 37.
37 is a new.
Yes, new.
Which wipes away the
entire by the order.
So how is it relevant in the present
It is
case?
relevant because it was relevant because prior to the act came into force, the suit has been passed and the order has been passed. And the appellate order, judgment also.
No, if no order by the collector has been passed to evict or to...
No, there is no order at all. When the London trial court has held that it is a self-occurred property and no partition is necessary at all, then the consequence will be follows.
All right. Heard Sri Tushar Mishra, Learned Counsel for the appellant. Peruse the impugned judgments, considering the submissions
Question number 2.
and the grounds raised.
And 3, my lord.
The second appeal is admitted on the following substantial questions of law. Page 10, 2 or 3 to
2 and 3.
issue notice to the respondents. Call for the LCR. List this matter.
Sir, 16th December.
16th December. And in the week commencing. Yes, 2 more matters.
Item 27.
There is an IA first, Your Lordship, that to be disposed of. IA that dispensing with. In the meantime, the trial court judgment certified copy has been filed.
IA not first.
Here the reversing judgment, my lord.
Who are you?
I am the landlord. Filed the suit.
plaintiff?
Plaintiff. Filed the suit for recovery of arrear rent, recovery of arrear rent, recovery of tenant possession of the tenanted premises, and other dues. That is the Lordship may read it. Suit for recovery of arrear rent and with estimated cost of repair such and such, and rent of 1,000 for the damages collected from 1/6/2016 till the date of record unlawful possession of the rented premises, which has been paid for cash possession. The trial court allowed but instead of 1,000 damages compensation, allowed 900 per day. Your Lordship, that page 49. Page 49. This should be, and the same is decreed in part on contest against the defendants. It is hereby declared that the plaintiff is entitled to possession of the suit schedule A land and the building, and the defendants hereby ejected from the forthwith. The plaintiff is entitled to get 5 months arrear house rent amounting rupees 1,25,000. Only electricity due such and such only, and 600 only towards water bill charges from the defendants. He is also entitled to get 900 rupees only for DM, that is on day-to-day basis from the defendants as damages towards the house rent from 1/6.
So what happened? Then appeal?
That when execution case was filed, no appeal was filed, execution case filed, he approached this honorable court in CMP when the attachment was going on. That was the CMP was disposed of, go to in appeal. The appellate court is issue tell that Your Lordship may see that page issue number 4, page 65, that is regarding the damages. He has dealt to it at page 89, last portion, Your Lordship may. Page 89. May I read for last portion? The learned trial, last part, 4th line.
Yes.
The learned trial court found that while breaches of agreement were established, the grounds for eviction and quantum of compensation are not adequately proven. The learned trial court awarded damages at a lower daily rate, reflecting different interpretation of the agreements provisions. The primary issue before the appellate court is whether the learned trial court's finding regarding possession, eviction, and compensation are justifiable based on the evidence and applicable legal. The respondents has here that respondents, the plaintiff, has established breaches of tenancy agreement, including non-payment of rent and other charges.
So as I find, the decree was modified.
Modified that no damages till the recovery of possession.
All right. Third Sri S. Sanapati, learned counsel for the appellant. Appellant or appellants?
Appellant.
Appellant. Peruse the impugned judgments, considering the submissions and the grounds raised. The second appeal is admitted on the following substantial questions of law. 1 ta haba?
Yes, sir.
C ta haba? Yes, Mr. Sanapati, 1 and C.
Yes.
1 and C. Issue notice to the respondents by registered post.
We also the same.
Call for the LCR. List this matter in the week commencing
16th December.
16th December.
Item 28. My lordship.
या पर गोटे मैटर जोटा पास ओवर हिची नेबे गोटे पास ओवर जो रही से गोटे मैटर नेबे बाकी हियरिंग केले.
Out of one judgment, 2 appeals were filed. One appeal has been admitted by the honorable court. खाली
ସେଥିରେ substantial question of law ଇଏ ର କଣ ସମାନ ହବ?
ଏକା ଜଣେ ସାର୍ ସେଥିରେ ଖାଲି କହିଥିଲେ ମୁଁ ଘର ଛାଡିଦେବି ଆଉ ମୁଁ
ହଁ ସେଇ ଯୋଉଟା ଘର ଛାଡିବା କଥା।
ଛାଡିଦେବି ମୁଁ ଖାଲି ପଇସାଟା କେତେ ଆଦାୟ କରିବି ଏତିକି କହୁଛି ତାର ବି ସାର୍ ଲେଖା ହେଇଛି।
You are appearing?
Yes, my lord. I'm filing my Bakalat.
23 ଇଏ କମିଟିରେ ଆସିବ ବୋଲି ଥାଏ ମତେ ଖାଲି କିଛି
ଏଇଥିରେ ଯାହା ଲେଖା ହେଇଛି ମୁଁ ପଢି ଦଉଛି।
ଏକା
It is further submitted by Mr. N.P. Parija that the appellant being the tenant is ready to vacate the suit premises if reasonable time is granted to him in order to collect the outstanding amounts from the market. ଆପଣ ଯାହା କହିଛନ୍ତି।
ହଁ ମୁଁ ଏହା କହିଛି ଯାଇଥିଲି ବି ରାଜି ମତେ ଖାଲି କିଛି ସମୟ ଦେଇଦେଲେ ମୁଁ ଲକ୍ଷ ଟଙ୍କା ଆଦାୟ କରିନି ଆଉ 7 ଲକ୍ଷ ଟଙ୍କା ପଡିଛି ଏତିକି ହଉଛି କଥା।
ଏଇଟା 27/8/2024 ହେଇଥିଲା କେତେ ଟଙ୍କା ୟା ଭିତରେ ଦେଲେଣି ଆପଣ?
ଲକ୍ଷ ଟଙ୍କା ମିଳିଛି
ମିଳିଛନ୍ତି ଦେଇଛନ୍ତି?
ନାଇଁ ମୁଁ କଲେକ୍ଟ କରିଛି ମୋର କ୍ରେଡିଟ୍ ସବୁ ପଡିଛି ତ ବାହାରେ ମୁଁ ଆଣିପାରୁନି ଏ ହଉଛି କଥା ଖାଲି କିଛି ସମୟ ଦେଲେ।
Yes.
My lord, let this matter come on same order.
Same order. Since you are appearing,
ଖାଲି ଅର୍ଡର ନମ୍ବର
then that will change. So here, Mr. Parija, it was said that parties are directed to inform the court as to if any concrete settlement as proposed has been arrived at हवा कथा. Anyway, it is the week commencing 23rd September थला. आरो week रे थला. माने आरो week राशि थला नहीं. So this matter will come the next week. Let this matter also come next week along with it.
Yes, ma'am.
ଆଉ ସମୟଟା ମତେ ଦେବେ ସେଇଦିନ ଆଉ କଣ ମୁଁ କରିବ ପଇସାଟା ମିଳିବନି ଆଉ ଆଙ୍କୁ ଦେବି ପଇସା ମିଳିବନି ଆଉ କଣ କରିବ।
ସେତିକି ସବମିଶନ କେବଳ ଏତିକି ଆଡମିଟ ହେଇଥିଲା ସେତିକି ସବମିଶନ କରିଥିଲେ ବୋଲି ଆଡମିଟ ହେଇଥିଲା ସେତିକି ଲେଖା ହେଇଛି।
ଆଜ୍ଞା ମାନେ ମୁଁ କଣ ମିଛ କହୁଛି ମୁଁ ତ ମିଛ କହୁଛି ଆଉ ଖାଲି ସମୟ ଦେବେ ଆଉ 5 ଲକ୍ଷ
ଏଇଟା କରିଦିଅ ଏଇଟା ଖାଲି କନସିଡରିଂ ସବମିଶନ ଲିଷ୍ଟ ଦିସ୍ ମ୍ୟାଟର ଇନ୍ ଦ ୱିକ୍ କମେନ୍ସିଂ 23rd September ଆଠ ଗଲା ଏଇଟା କରିଦିଅ 28th October ରାଇଟ୍ ସେ ମୋର କରିଦେଲା ସେଇଟା ତା ସାଙ୍ଗେ ଯାହା ଲେଖା ହେଇଛି କରିବ
ଖାଲି ନମ୍ବରଟା ବଦଳିବ ମିସକେସଟା ବଦଳିବ।
ୟେସ୍ ଦେଖ ପାସୱାର୍ଡଟା କାହାକୁ କିଛି
So the item number 16.
ମତେ ସାଉ ନେଇ ହବନି ଆଜି ହିୟରିଂ ମ୍ୟାଟର ନେବିନି କାଲି ନେବି। Yes.
Lord, this is a challenge to the order of the learned district judge.
This has come for orders for dispensing with filing of certified copy.
My lord, the dispensing of certified copy is the judgment dated 21/3.
Have you filed it?
No, that is dispensing. That's the order of the trial court.
Yes.
But as far as the certified copy of the judgment which is under challenge, it has been filed before the judge. The certified copy.
A certified copy of orders dated 21/3/2023 in CS number 302 of 2020 by the Learned Commercial
That
Court.
is the dispensing application which has been filed. The order under challenge, the certified copy has been filed 9/5/2024.
So why is this IA required? Why is that certified copy required?
But that's inadvertently filed. But otherwise, the certified copy challenging the order has been.
No, are you challenging the order of the commercial court?
No, my lord. The challenge is to 9/5/2024.
No, just a moment. You see, there are two orders. First is of the CS number 302 of 2020
Yes.
of the commercial court.
Right.
Against that, you filed appeal.
I filed the regular first appeal.
But I don't think a regular first appeal is maintainable. There's a commercial appellate division, I think.
My lord, when it comes to because what I think is, if your lordship will take up give me that act.
In the High Court also, we have a commercial appellate division.
Yes, my lord. I think it's the jurisdiction, the pecuniary jurisdiction, because the relevant section 13, right?
No, the district judge is also an appellate authority.
Yes.
But not as district judge, as appellate authority or some appellate division or something like that, please.
That is what it is written actually.
Has it been written here?
Yes.
No, he has disposed it off as a. But this is nothing to do with your case, but anyway. So what happened?
My lord, the regular first appeal has been dismissed on the ground of 72 days delay. I go before the trial court, I give a complete, before the learned lower appellate court, give a complete reasoning that my advocate never informed me. And therefore, there is a delay of 72 days, which should be condoned.
But the district judge says no, that the particular explanation given is not convincing, and therefore I'll not condone that 72 days and dismisses the regular first appeal. I have a.
What was the case for? What was the original case?
My lord, the original case was, if your lordship will go to page 12, I'll just tell the parties here.
Page 12.
Page 12.
Yes.
The appellant before your lordship was defendant number 1. The respondent number 1 is the one who was supplying cartoon boxes to defendant number 2. They have entered into an agreement. They are the ones, when the purchase orders were issued by the defendant number 2 to the plaintiff used to issue the invoices to the defendant number 2. I have nowhere in the picture. In fact, defendant number, the defendant number 2 is
Sahara Enterprises.
Yes, is my distributor. I have a I have a trademark agreement with him. I have nothing to do with it, with both of them. Okay. And after having been my distributor, he enters into an agreement with Sahara. Sahara enters into an agreement with Agrini.
Okay.
Who's the plaintiff?
The recovery of 13,92,090.
Which has admittedly not been paid by the defendant number 2.
Okay.
Because I'm nowhere, I'm not a privy to.
No, but how does the plaintiff rope you into the picture?
Because I have entered into an agreement with the defendant number 2 for dealership.
Okay, so that was decreed. Suit was decreed.
Suit was decreed, and as far as the decree is concerned, as far as the order of the trial court is concerned, the trial court says that both of us are jointly and severally liable. In fact, if your lordship will look at the trial court order, because I didn't want to go into that, because your lordship will personally, I would pray that your lordship may remand this matter back, because it's
not at this stage. Without issuing notice, how can I admit? I'll admit it.
Finally,
I'll have to formally admit it.
Absolutely.
I'll have to formally admit it.
Finally, it has to be, because that's the last fact-finding court.
No, but if the court, if only the court considers the grounds raised by you to condone the delay to be sufficient,
absolutely.
The court will condone the delay,
right.
And then obviously it will be remanded for consideration of the appeal afresh.
I was just praying that I was just submitting that this is a fit case to be remanded, if at all your lordship considers that I have a case as far as the delay part is concerned.
So delay, let us see how she has dealt with it.
If your lordship will look at page 13.
Page 13, okay.
12, the order of the learned district judge starts, and at page 13. About second paragraph, about 10 lines from the top, the conducting advocate has also not informed till disposal of the suit, for which the appellant could not know about the fact of disposal of the suit by the impugned judgment and decree. When the appellant came to know about the impugned judgment, he applied for the certified copy and judgment and decree on 22/7/2023, and after obtaining certified copies, he preferred the appeal. It is averred that the non-filing of the appeal in due time is not intentional. Now, if your lordship will go to the finding,
the court does not accept your grounds, that's all.
The district judge says that your advocate appeared. He examined the witnesses. He cross-examined the witnesses for the plaintiffs. And therefore, you are at fault. But my contention was my advocate never intimated me.
All right. Lord Sri Srivashish Mishra, learned counsel for the appellant, perused the impugned judgment, considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Whether the first appellate court was justified in rejecting the grounds raised by the appellant to explain the delay caused in filing of the appeal, and thereby rejecting the appeal in its entirety. Stop. Issue notice.
There's an application for stay. We have received a notice from
No,
the.
there's no application for stay.
Yes, my lord. This is I number 965 of 2024.
No, it has not come. Dekila. Issue notice to the respondents by registered post, returnable within 4 weeks. Requisites be filed within 3 working days. List this matter. The call for the LCR. LCR is necessary? I don't think so.
No, my lord.
LCR is not necessary. Oh.
965.
Listen. Yeah. Call for the LCR. List this matter in the
Your lordship will look at page 7.
in the week commencing 16th December. IA 965 of 2024. Yes, what has happened?
Your lordship will look at page 7 of that IA.
The further proceedings in execution petition number so and so pending before such and such court shall remain state till the next date.
Very great.